Where it stops, no one knows. We're going
That was a weird ending to the intro.
Whoopsie, I removed you. My bad.
Was that you that did that?
Yeah, I forgot who I was.
Oh, that's hilarious. I was like, wait a minute, what is going on?
We're really
right,
the
well,
same person. This is a very detailed and highly complicated ventriloquist act on this channel, in case anybody didn't know.
You guys would never know. You'd never know. You'd never be able to guess. Well, I'm having issues with my computer, so I'm trying to restart it. So I am on my phone. So I'm going to say hi to everybody. Good morning. Happy Tuesday. Welcome back to Criminality. Or if this is your first time here, welcome to Criminality. We are covering the state of Massachusetts versus Karen Reed in her retrial. We are on day number 26. We left off yesterday with cross-examination of Dr. Marie Russell discussing dog bites and whether she's a dog bite expert who advertises on Craigslist. And we have now confirmed that Brennan is a fucking idiot. Other than that, I think you guys all know where we were.
Yeah. Also, there's a new filing.
There is. Okay.
Well, there's a couple. If I don't have to pull it up, because I'm adding several filings to the Google Drive and then the sheet. So if I don't have to pull it up, I can read it to everybody right now. Otherwise, you'll have to wait. But the missing witness one is here, and it's
I don't think they need to see it. They just want to hear about it. So yeah, what is it? It's
more than one person.
What? Who is it?
Okay, so now comes the defendant, Karen Reed, and respectfully moves this honorable court for what we don't need to. Allowing Ms. Reed to present a missing witness argument would best position the jury to consider all of the evidence at issue, including what is missing from the Commonwealth's case and their deliberations. It is appropriate for the court to give a missing witness instruction where a party has knowledge of a person who can be located and brought forward, who is friendly to, or at least not hostilely disposed toward the party, and who can be expected to give testimony of distinct importance to the case. The party would naturally offer that person as a witness. If then, without explanation, the party does not call the witness to offer testimony, the jury may infer that the prospective witness would have given testimony unfavorable to that party. The underlying premise of a missing witness instruction is that a party's failure to call a prospective witness raises a reasonable inference that this witness would have provided testimony adverse to that party, and a jury should be afforded the opportunity to consider that information in their deliberations if they deem it to be reasonable. A trial judge has discretion to refuse to give a missing witness instruction requested by either party. However, cases supporting the need for judicial caution in permitting an adverse inference are inapposite. It looks like inopposite, but it's spelled with an A. When the inference is to run against the Commonwealth because there is no constitutional concerns to warrant the call for caution in such instances. Notably, the degree of judicial discretion may be lessened when it is the defendant rather than the Commonwealth who seeks approval of a missing witness argument. All right, you ready? Basic to the inference is the existence of evidence of physical availability of the witness and the likelihood that he can be produced by summons or otherwise. Michael Proctor, Brian Albert, and Brian Higgins were all listed on the witness list presented to this court by the Commonwealth. There has been no showing of physical unavailability for any of these three witnesses. Additionally, the defense is informed that Brian Albert and Brian Higgins were both under subpoena by the Commonwealth. Michael Proctor, Brian Albert, and Brian Higgins are all friendly to the Commonwealth. All three witnesses testified cooperatively in the 2024 proceedings as witnesses in the Commonwealth's case. There's no reason to believe that these individuals would not continue to cooperate with the Commonwealth as friendly witnesses less than a year after their prior testimony. Additionally, the fact that Ms. Reed could call these three witnesses does not render the adverse inference impermissible because the Commonwealth is more acquainted with these witnesses and would be naturally expected to call them in establishing their case in chief. A missing witness instruction may be properly given where the prospective witness is more friendly to one side than the other, even if the witness was available to the party requesting the instruction, which we did not know yesterday. We thought, in reading it, I thought, and I know other people thought, that if they were available to be called by the defense, then they wouldn't be able to get the instruction. It says each of these three witnesses would offer
No, it doesn't matter about availability. It's just going to be, the problem is going to be, it's up to her discretion, and she's not going to give a shit.
Mm-hmm. Right. Each of these three witnesses would offer meaningful testimony that is neither cumulative of other witnesses that have been called, nor would their testimony be unimportant. I have like a frog in my throat. Michael Proctor's anticipated testimony would not be duplicative of other witnesses called by the Commonwealth and is central to this case. So that's why they didn't have the friend read the text. But they still have a good argument because, like I said yesterday, I had just literally realized that like some of the badder ones, I mean, not badder one, not worse, but like the one about hoping that she kills herself and getting the gift. Julie wants to get a gift, blah, blah, blah. That stuff's not in yet.
Well, no, because that's to Courtney.
Testimony of the lead investigator in this case is of great importance to this case, as the role is inherently unique compared to other witnesses, both civilian and law enforcement, put forth by the Commonwealth. Michael Proctor was the lead investigator and was responsible for recovering a significant amount of evidence in this case. Moreover, Sergeant Buchanan's testimony confirmed that nearly every piece of evidence recovered in connection with this case, including all of the taillight pieces recovered at the scene, Mr. O'Keefe's clothing, Mr. O'Keefe's cell phone, and the surveillance video from the Canton Police Department, were in Michael Proctor's sole possession for months or years before they were booked into evidence.
See, and then the Commonwealth's going to argue here that it doesn't matter. It is duplicative because they already had Bukaki testify to all of this.
Yeah, but remember when they said, like, so what happened in that period of time, you know, the month or whatever, where his clothes weren't booked into evidence? And he's like, I don't know. Or when people are like, I left it with Michael Proctor. And they're like, well, where did it go after that? Well, I don't know. Well, Michael Proctor's the only one that can. If you remember, Buchanan was not allowed to say what we did to include Michael Proctor. So I think there are something. While I do think they tried to get as much out as possible, I don't think they got everything from Buchanan. So similarly, neither Brian Albert's nor Brian Higgins's anticipated testimony would be duplicative of other witnesses called by the Commonwealth and are each central to this case. No one except for Brian Albert or Brian Higgins themselves can testify to their exact whereabouts within the home at 34 Fairview on January 28th and 29th. Sarah Levinson's and Jennifer McCabe's testimony are not sufficient to support the claim that John O'Keefe never entered the curtilage of 34 Fairview, as they were not all together the entire time they were at 34 Fairview, leaving Brian Albert and Brian Higgins each with the opportunity to interact with John O'Keefe within the curtilage of the home without any other witnesses being aware. Specifically, no other witness has testified thus far, or even would be able to testify to and be meaningfully cross-examined about the reasons for Brian Higgins visiting the Canton Police Department around 1:30 a.m. on January 29, 2022. Additionally, no other witness has testified thus far or even would be able to testify to and be meaningfully cross-examined about the reasons why Brian Albert, a trained first responder, and his wife did not come outside around 6 a.m. on January 29, 2022, when their bedroom was mere feet from the scene of drastic life-saving efforts by paramedics and firefighters, response by police officers and their respective cruisers with lights, and the sounds of 3 women discovering a loved one unresponsive in the snow. By the way, some of this is redacted, so. If the Commonwealth provides Your Honor an explanation for not calling an available witness and that explanation is sufficient, the missing witness instruction can be properly rejected. An explanation is sufficient where the trial judge is satisfied that the circumstances thus offered would, in ordinary logic and experience, furnish a plausible reason for non-production. See, I don't think that the Commonwealth is going to have a plausible reason other than it's bad for our case, so we didn't want to include it. Here, the Commonwealth has not, and cannot provide a sufficient explanation for not calling Michael Proctor, Brian Albert, or Brian Higgins. The Commonwealth understands the risk that the testimony of these 3 witnesses pose for their case, as all 3 are highly susceptible to impeachment on relevant and non-collateral issues. The Commonwealth is consciously choosing to obscure and hide from the jury the complete picture of what occurred at 34 Fairview Road on January 28th and 29th. Conceitedly, witnesses may be withheld because they are susceptible to cross-examination on collateral issues or for other tactical reasons. But that is not the position the Commonwealth is in with these 3 material witnesses. All 3 of these witnesses are susceptible to cross-examination regarding issues that are central to this case. Number 1, Proctor's handling of the investigation and relationship with the very witnesses who should have been suspects in this case and subsequent termination from the Massachusetts State Police as a result of his conduct in this case. 2, prior admissions by Brian Albert and Brian Higgins that they left the rest of the group at 34 Fairview Road for a period of time in the early morning of January 29th, 2022 to look at photographs in some other part of the house. Number 3, 4, 5, 6 are all redacted. There is a critical distinction between argument by counsel that argument presented by the Commonwealth is insufficient and a missing witness argument. A defendant has wide latitude in any and every case to argue that the Commonwealth has failed to present sufficient evidence and that there is an absence of proof or that evidence is missing. A missing witness argument is distinctly different from this scenario. While both allow a defendant to argue the Commonwealth did not meet their burden of proof, in the former, the defendant argues that the evidence that has been produced is inadequate, and this can legitimately include pointing out specific witnesses or evidence that have not been produced. However, in order to argue or ask the jury to draw any conclusions as to the substance of the evidence that has not been produced, counsel must first seek judicial consent to present such an argument and have a subsequent instruction follow suit. A significant portion of Ms. Reed's defense has been focused on the inadequacies of the investigation into the death of John O'Keefe and the lack of consideration of other suspects. A judge is required not to take the issue of adequacy of the police investigation away from the jury, not affording Ms. Reed the opportunity to argue that the jury should draw adverse inferences from missing witnesses in the Commonwealth's case that are deeply involved in the investigation itself will erroneously remove from the jury's consideration the precise issue sought to be raised by the defendant. This jury should be provided with the necessary framework for considering the absence of evidence or witnesses should they deem it relevant information to their deliberation and assess the weight and significance of the missing evidence or witness in relation to the evidence presented against the defendant. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court allow her to present a missing witness argument and grant the subsequent instruction. So it's not just an instruction, it's an argument too, which I guess I guess in their closing argument, they would say the Commonwealth, but God, the closing arguments are so limited in time. It's like, how much are you really going to get in? All right, so then there's proposed jury instructions. There's also a motion for reconsideration of her order excluding the testimony of defense expert Michael Easter. And I'll skip this stuff. On March 31st, 2025, this court allowed the Commonwealth's motion in limine, or limine. I don't know. Dude, if I was sounding this out, it says limine. to exclude defense expert Michael Easter's opinion of the investigation. In doing so, the court explained that expert testimony is not needed because the defense, through zealous cross-examination of police witnesses, can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures. The defense respectfully requests that this court reconsider its decision in light of the fact that the Commonwealth only called 2 police witnesses responsible for investigating O'Keefe's death in its case in chief. I didn't really realize it was only 2. That's crazy. Canton Police Department Lieutenant Gallagher and Massachusetts State Police Sergeant Buchanan, both of whom refused to concede investigative failures. The defense should not be forced to adopt the self-serving opinions of these particular law enforcement officers regarding the reliability and adequacy of their investigation. Massachusetts law firmly supports a criminal defendant's right to challenge the adequacy of a police investigation through a Bowdoin defense. As the Supreme Judicial Court held in Commonwealth v. Bowdoin, a jury may consider the fact that certain tests were not conducted or certain police procedures not followed to assess whether the investigation was deficient. Evidence of investigative failure may raise reasonable doubt, and precluding such evidence improperly removes this determination from the jury. Importantly, expert testimony may be introduced to support a Bowdoin defense where the subject matter lies beyond common knowledge. And then it quotes some things and says, encouraging courts to exercise discretion as to the introduction of particular testimony that could help a jury understand information that is beyond their common knowledge. Such testimony is particularly appropriate where the expert can explain how an investigation deviated from professional norms, especially when based on articulated standards such as departmental policies and procedures. The purpose of expert evidence under Mass Rules of Evidence is to assist the jury in evaluating the significance of technical failures that may not be readily understood through lay observation alone. This court's order allowing the Commonwealth's motion to exclude Michael Easter's testimony presumed that zealous cross-examination of Commonwealth witnesses would suffice to expose all investigatory deficiencies. However, as set forth in Commonwealth v. Reynolds, the defense should not be forced to accept the Commonwealth's witnesses' testimony regarding what constitutes standard policies and procedures based on what they are willing to admit, which makes perfect sense. The court noted that, so in United States v. Polson, the court noted that just because the defendant could have attacked the investigation solely through cross-examination, this did not preclude the defendant from introducing expert testimony on this issue. As the Reynolds court emphasized, the defendant should not have been precluded from eliciting evidence on the question simply because the Commonwealth asserted that the investigation was adequate. A defendant is not bound to merely accept the opinions or admissions of the Commonwealth's witnesses and is entitled to present its own expert to explain what the appropriate standards are. Here, the defense must be allowed to introduce testimony to affirmatively show how the investigative conduct in this case failed to meet accepted standards, not merely suggest as much through implication or adversarial questioning, particularly where here the law enforcement officers failed, unsurprisingly, to concede that their own conduct was deficient. Recent trial testimony has materially altered the posture of this evidentiary issue. Lieutenant Paul Gallagher and Trooper Yuri Buchanan each testified to conduct which clearly deviated from standard law enforcement protocols, but refused to concede any wrongdoing. Over the course of 2 days on May 5th and May 6th, Lieutenant Gallagher testified to his account regarding evidence collection outside of 34 Fairview Road. Lieutenant Gallagher stated that he used a leaf blower to clear the area and uncover crime scene evidence, a method ripe with a substantial risk of disrupting or destroying evidence, was proper and effective in this instance. Further, he testified that because of the weather, it simply would have been impossible to follow protocols. Finally, Lieutenant Gallagher admitted that he chose not to search the home adjacent to the crime scene, owned by a fellow officer, falsely claiming lack of probable cause, and that it would be improper for him to attempt to obtain consent. That testimony was incredibly misleading, and there is a significant risk that jurors will give his testimony undue weight merely because he is a law enforcement officer and lay witnesses are unfamiliar with the legal standards attendant to criminal cases. Trooper Yuri Buchanek testified over the course of 3 days on May 8th, 9th, and 12th regarding his involvement in the investigation and asserted that this investigation was conducted with honesty and integrity. The defense is entitled to rebut his self-serving claims. Trooper Buchanek admitted that he never entered the house at 34 Fairview Road to search for evidence, interview witnesses, or to photograph the home at 34 Fairview Road on January 29th. Furthermore, Trooper Buchanek failed to explain the divergence from the normal chain of custody protocol, noting that while certain evidence was discovered on February 3rd, 4th, and 10th, it was not written in a report until November 4th, 2023, almost 18 months later. He also fails to offer an explanation for failing to interview two potential witnesses, Ricky D'Antano and Heather Maxson, who were at 34 Fairview Road until over a year later. Furthermore, Trooper Buchanek admitted that there was evidence logged that he himself turned over where he could not identify who eventually filled out the evidence label. He claimed that there was nothing unusual with the handling of the evidence in this case. Proper chain of custody protocols are not common sense issues that are apparent to laypersons. The defendant is entitled to call an expert witness to testify regarding proper chain of custody protocols. The investigation in this case was clearly inadequate and deviated from standard policies and protocols. The defense is entitled to call an expert witness to establish that this case did not conform to standard or accepted protocols. The Commonwealth therefore opened the door to testimony by a qualified expert who can clarify for the jury what those protocols actually are and why these departures matter. Just as jurors are routinely aided by expert testimony, police regularly testify about information for which specialized knowledge would be useful, even if information could be general for a certain juror. Thus, Ms. Reed should be permitted to proffer testimony from a seasoned FBI agent regarding investigative principles, policies, and professional standards. Michael Easter's testimony, rooted in the Massachusetts State Police Policy and Procedure Manual and decades of experience, falls well within this permissible scope. In Commonwealth v. Wood, the SJC explicitly upheld the right of a defendant to call a forensic expert to challenge the adequacy of an investigation. The court emphasized that the jury had the benefit of 1, cross-examination, 2, closing argument, and 3, the calling of its own expert as part of the Bowdoin defense. That trifecta is precisely what the defense seeks to employ here, and the removal of one of those legs unjustifiably undermines the defendant's constitutional right to present a complete defense. Even if jurors may intuitively recognize some investigative irregularities, they are not equipped to assess whether those actions violate codified procedures, create contamination risks, or reflect investigatory bias. I agree with that. The argument that a lay jury can adequately gauge the seriousness of Lieutenant Gallagher's use of a leaf blower or Trooper Buchanek's failure to appropriately comply with chain of custody protocols without the aid of expert testimony is unsupportable under relevant case law. And the conclusion, Trooper Buchanek and Lieutenant Gallagher's testimony revealed significant investigative deficiencies, yet these law enforcement officers have asserted that their investigation was not only adequate, but was conducted with honesty and integrity. The defense must be allowed to present expert testimony to place that conduct in context, explain its implications, and allow the jury to determine whether the deviations are material to assessing reasonable doubt. For the above reasons, Ms. Reed respectfully requests that this honorable court reconsider its order excluding Michael Easter's testimony. And I don't know if they addressed this in court this morning. Let me see here. 707. We won't get into this right now. I'd rather watch court, but the defendant filed proposed jury instructions, and so did the Commonwealth. And I think that's all the new ones for today. All right. Let's get this started. Court TV. Nope. All right, hold on. Nope, I don't see anything that happened this morning, so. Oh, and I don't know if everybody saw yesterday. I retweeted it and I put it in the chat on Teresa's chat. Yes.
May have lucky charms.
Yes, you may. That the next three witnesses are said to be Lucky, the plow driver, Karina Kolakithis, and Nicholas Barros. So, but we're finishing the cross of Dr. Russell.
Oh, good morning, Ms. Reed. Good morning, jurors. I have to ask you those same three questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no or should. Does Dr. Russell in the back there? Mr. Brennan, you can set up if you want to.
Doctor, I'll remind you, you're still under oath. Thank you.
Thank you.
Good morning, Dr. Russell.
Good morning, Your Honor.
May I?
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes,
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say? I
wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Sleuthie.
And Mr. Sleuthie, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so did Mr. Sleuthie help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Sleuthie did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you just
please.
testified to. You want to
Yes.
see it again?
Yes.
Okay. By the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That was my.
Well, it's smart because you lie like a rug, but also you look really stupid to me. Going over and over again with this lady about how her opinions got more firm. She became more firm in her opinion over the course of a year. That didn't change her opinion, just changed how certain she was of her opinion. Meanwhile, you got no degree Burgess, who is entirely changing his opinion. He says he was making it more accurate, but the fact of the matter is that the information changed in the middle of trial. You look so stupid. And he's got an attitude this morning, so I don't know if he read the reviews online last night, but I find it very hard to believe that he found a bunch of good reviews saying that he did okay, but it would be better if he was a dickhead this morning.
That's my general advice from.
Oh, and I saw something with Sue O'Connell where she says one of the jurors, when she refers to her, she looks like she thinks that Dr. Russell is her grandma. So I think the jury really likes her. So I really don't think being a dickhead is going to be good for Hank. I mean, I said that before, but yesterday he seemed like he was going to not do that. But today he seems like he's going to do that.
Previous times.
Well, did you have any advice last night about that?
I hope not, because I'm pretty sure that witnesses aren't allowed to talk to the attorneys while they're on the stand.
Yes.
Oh,
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Lessie.
Oh, fuck.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
God damn it.
Yes.
A sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during the
didn't, we didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I did
order
not.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday. No. Not in the car yesterday. No.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to the sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver. Yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride home, back to the hotel yesterday with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red
That's-
Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some concept. There must have been some context. He didn't just turn to you talking about the weather and say, "Hey, you should ask for a transcript." You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask
I-
for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just at the court. You can't remember the context of the sage advice of Attorney Alessi?
No.
You have any memory issues?
No.
May I approach?
Yes.
Transcript. Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
That looks consistent.
You want more time with the transcript?
No.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date,
Yes,
may I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm gonna strike that, disregard that, Joyce.
May I approach?
Yes. What page you want, Mr.?
23. June 21st, 2024, Doctor?
June 21st.
Page 23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you. Have that back?
Yes, you may.
Okay, thank you. When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it,
Sure.
that sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
Then I'm sorry. Please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Do you remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest there's some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes,
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you describe methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source, there is no recognized community, there's no certification, there is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer review articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal,
I mean, surely that would be in her report somewhere.
one book. Can you point to any?
Passenger, I think they're letting her go through this because he looks like a total douche.
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. DeMunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach.
Seriously?
Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
Where's this dog bite community at? How do we find list?
No.
And so with no readily accepted standards in the dog bite community, no defined methodology, you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation
Well, one
that
doesn't
has been
exist.
published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make and nurse practitioners and the like make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here.
Yeah,
So
like
let's
she
focus
just
on
said.
dog bites, if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph.
So wait a
and
minute. He's going to say that there's no accepted methodology, this and that. How does he plan on having his expert come and talk about the same things? I don't understand. And people get bit by all kinds of animals all the time.
just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the methodology and the articles that I read, the numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a, methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine.
Oh, dear God.
Dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out. You sought the case.
That is incorrect.
And
So her seeking out the case to offer an opinion, how does that mean she has confirmation bias? Like, does he not understand? This man gave Dr. Welcher interviews of Karen Reed, witness statements, a bunch of random shit that had nothing to do with what he was supposed to figure out. But I'm sure he got all the things about I hit him, right? I would think that that would cause confirmation bias, just like when he said, I can't say when it happened. I don't know how fast she was going when she hit him. I can't say definitively that that's like what happened, but when you take into account the DNA and the pieces of tail light and this and that, then it like basically makes sense. It's like, sir, what?
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case, and I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions?
I'm pretty sure like her considering that it could be something else means she doesn't have confirmation bias.
And wounds. What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
Ew,
No.
what a total fucking asshole.
I would like to put up an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for the sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2,
Yes.
number 3,
Yes.
4,
Yes.
5.
Which did
I'm
you call
sorry, this
4?
one,
4,
5.
5, 6, maybe.
Okay, so as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion. So
Do you think the jury's sitting here thinking like, what? Why is he spending all this time on dog bite if they know that this was the tail light?
we can have clarity. Is that
Okay.
fair?
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the
Do
transcript.
you remember when you were first giving opinion testimony about this specific abrasion?
He acts like calling it he acts like calling it a superficial abrasion is inconsistent with her opinion. It's not.
Wound number 1. Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
She wants the fucking transcript,
Do you
dickhead.
remember your testimony?
No, give me
For
the
each
transcript.
specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion,
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always.
He keeps talking about that he's going to give her the transcript. I've heard him say so many times that he's going to give her the transcript, like just give her the transcript and let her keep it because you're clearly going to keep referring to it. And if his suggestion here is that she changed her opinion, I'm still not seeing where she changed it. I'm seeing where she became more firm in the opinion she already had.
Always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't
I wish she'd say, it didn't come from a taillight. That's for damn sure.
be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
I mean, I
Are you saying
understand
that
that.
nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
Yeah.
I'm saying that they can cause similar looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell
Objection.
the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern.
The problem is she's not suggesting, like, if she can't differentiate between the teeth and the nails of the same animal, that's entirely different from being unable to tell if it's from a piece of glass, from a piece of plastic, from gravel in the road. Like, he's acting as though if she can't say whether it's teeth or nails or a combination of both, that automatically that means it's neither one. That's false.
In order to make some conclusions.
But when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No,
It wasn't until I began asking you questions
No.
and you had inconsistent answers that you've now changed from, rather than identifying individual
No.
wounds, now you're saying I can't identify individual
the
wounds,
overall
but I can tell
pattern.
you the totality.
I disagree with that. I believe that in the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth to a reasonable degree of medical certainty? You're not sure? What is the...
I'm 100% certain that it's from teeth and I believe it's only one cluster of like, I think there's only one cluster that she's saying she's not sure. I'm positive that it's teeth and or claws.
value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty
What is a reasonable degree of medical certainty? That what?
that those are caused by teeth.
Teeth. Okay. When you first testified, your position was
Yeah, bitch. I've been looking at it for a year now. Now I'm pretty sure.
it could have been teeth or nails. That is different than saying to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
Neither
When
of
you
which are
first
tail length.
testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder,
Hmm.
right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Nails on a dog, oftentimes or most times, are horseshoe shaped, aren't they?
They're generally conical shape.
You
Yes,
don't
no,
think
that
that
word.
nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, at the end of the paw. They come to a point. And by the way, the paws can open and close. So the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
I posted, I said, Jesus, on Twitter. I said, Jesus, did someone spike Hank's morning Slim Fast shake? I find it hard to believe that the jury is okay with the way he's speaking to Dr. Russell. And the Karen Freed account said, I can't watch yet due to work, but I remember yesterday he was trying to be calm and even apologized to her for being sharp. And this Heather Nose says, that was fake. He is back to being king cunt in the courtroom.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year, teeth or claw marks, right?
I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
Any approach?
Yes. When you first testified on June 18th, doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin. And you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay, so that sounds like exactly what she's saying now. What a see, did you see that? They're not gonna like that bullshit either.
Dr. Russell, I'm just going to ask
Watch
you
his
to keep your
face.
voice up, okay?
Okay.
Like, are you fucking serious? Let her read it, you dickhead. If you don't want to stand there and wait, go back to the podium and let her tell you when she's done. God damn. Also, maybe make another copy and let her keep it.
That was your first testimony last year, yes?
Yes.
And then did you test?
Now, if this were the defense, Bev would be interrupting to say, can't we get her another copy so she has her own up here so we don't have to keep coming back?
Testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report,
Yes.
after your consultations, do you remember changing that opinion regarding
No.
number one? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes.
Okay. The pointy teeth, the big ones, those are called canine.
You know what he's not touching on? I'm pretty sure that it went from large animal, possibly dog, to it's definitely a dog. But I don't think that she said like the teeth and nails of a large animal, possibly a dog. You know? Different size teeth again. Yeah, I don't know. I literally don't know. Don't leave us, Lacey. If he makes her cry, like he's done for.
Canines,
Correct.
and the smaller ones are incisors.
Correct.
There's 6 incisors and a
This little bitch is saying incisor, so now we know that he knows how to say it. So I better never hear him say incisors again.
healthy dog on the top and bottom between the canines.
Correct.
What a little punk bitch.
Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony
Nope.
from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
Nope.
I became more certain, yes.
Give me the receipt.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
She had a whole ass
And
ear
so
to-
after you did your report, you shifted from
How in God's name can he get worse? Other than actually making her cry.
teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times. and challenged. And each time I reviewed the case, I became more certain that these were from canine teeth.
Say-
And actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Is the canine tooth a tooth, Hank?
Top-
Canines are
You know it's not a tooth? An incisor?
some of the teeth.
upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall
Which would be expected, that he would try to pull his arm away from a dog that's biting it.
that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be
I don't believe anything you're saying. Read exactly from the transcript. Give her the transcript.
in backwards. Remember that conversation we had?
No, I don't trust your ass.
Do you remember that conversation? You said that the point of entry would be the bigger circle,
I
pulled
don't
this
remember
way,
it. I
and then I
was-
questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that
Don't
at
remember
all.
that conversation
No.
we had? Okay.
Bring the
And
transcript.
so
What is he going to move on without showing the transcript? Bring the transcript.
inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However,
You need more than one thing to create a pattern, sir. Use pattern recognition, sir.
as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound up
Yes.
there, closest, I agree.
Unless
Yeah.
it was a
In
one-tooth
fact,
skull.
you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear.
Of course.
Same thing with number
Luckily,
three. You've
there's not just
provided
one.
opinions on this before. If you look at this wound alone, in
only
isolation,
is alone,
you
though.
would not be able to say that it came from a dog bite.
Correct.
Four, pardon me. Yep. Four,
Mhm.
same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for five and same for six.
Correct.
Now, when you testified before your recent
I'll
testimony,
check Indian.
you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number two, what caused this wound, Dr. Russell?
Number two, I believe that was dog bite or scratch, but mostly I believe dog bite.
Yeah, it looks like he's.
And because there's a punctate, little tiny pinpoint almost lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about
Me too.
Brennan is such a little bitch.
I know. I want to mute myself so that I stop saying, but then I keep pausing and unmuting anyway. But I want to stop saying things, or we'll never get through it. But he just has me so like it is passenger. It's like harassment. Like I don't understand because she's not a dickhead to you. This is
No,
entirely.
there's no reason he's being so disrespectful to her.
It really, I mean, he really is. I mean, I'm quite surprised that, and like, let's say the jury's sitting there listening. The whole comment about whether she has memory issues may not, like, as a juror, and especially a young one, you might be like, that's like not that offensive. But the fact that she gasped, audibly
Yes.
gasped, and was that offended is like, okay, well, even if I wouldn't find that offensive, she clearly was really offended. So, like, why is he offending her?
Well, it's just, I think it's
It's not
disrespectful.
combative.
Like it's just, I don't even understand why he felt it was necessary.
Like, did he talk to Lally and McLaughlin and they were like, you know what, you should be a total douchebag tomorrow morning? Like, I find that so hard to believe. Like,
Well, I think that he realized that she was a very good defense witness yesterday.
yeah, maybe.
So he's coming in to try to destroy anything he can. But I mean, from what I've seen so far, she's holding her own. And I don't think that even with the hiccups of whatever he thinks he's getting, I don't really see them affecting her testimony. Now, people on the jury are either going to believe, yes, this is from a dog, or they're going to think, no, it's not from a dog. I really wish that, like, when was it Welcher? I believe it was Welcher.
Mm-hmm.
Had the PowerPoint with the other accident victims. I
Yeah,
wish that she had some slides with some other dog bite victims. I mean, I've seen people posting all over social media, every platform, dog bites that look very similar to this. And I wish that she had something like, these are dog bite cases I've worked on. These are dog bite cases I've studied, you know, like,
but they don't usually die. You know what I
this.
mean? People don't usually die. Like, they don't usually, I mean, unless it's a kid, which you could tell haunts her to this day, the little boy that was attacked by multiple dogs that died. But people don't usually die. So it's like, then you'd have to have permission for these people, and then they'd probably be required to come in, like, unless you're using something from like a textbook. But unless you know that exists, like, that'd be really difficult to find. You know what I mean? Something that specific. But
I don't think so. If you look all over social media, people have posted photos all over. So, and I'm sure that they're in these.
Well, yeah, but you'd have to contact those people. You would have to make sure that that's actually what happened. But don't forget,
I'm sure she has plenty from the ER.
Do not forget that both of the ladies that got hurt by Chloe, I think it was her voir dire, wasn't it? Where they showed the injury to her hand or whatever. Do you remember that?
No.
Oh, you don't remember that? I think it was her voir dire where the defense showed a picture of the lady that got attacked by Chloe, her hand injury.
He doesn't die from the injuries to his arm, though. So I don't know if the person needs to die, because the whole point is that he gets hit by the car and the taillight falls down, hits his head. So if he gets attacked by a dog, falls down, hits his head, he dies from the head injury, and that has nothing to do with either the taillight or the dog. You know what I mean?
Yeah, but
so I don't think they need people that died.
But how different would the wounds look in this particular circumstance, where he's outside in the cold weather for however long they're saying it was, 5 hours or whatever, or the fact that he died really quickly, so maybe a bunch of inflammation around the tissues didn't happen. You know what I mean? Like,
to me, it looks like the arm is down and the dog is scratching the shit out of the arm. That's what it looks like to me.
Some of these, I always was of the opinion that, like if you were going to tell me these were bites and like this is a bite, I'm with you on all that. These seem like the dog like jumping on him or like you said, laying down and like trying to hold them with their claws. That looks like, especially like these.
Well, like a dog digging is almost like what I imagine. Like, that's what that looks like to me.
Yeah.
Like, you know, when my dog like scratches at me to like get my attention.
Yeah.
Like, she doesn't know how big she is. She thinks she's little, but
oh Lord, yes. Oh yes. Apollo was the biggest baby. He had no clue what he was functionally, brain wise. He was a baby. Like, he was only 9 years old and he weighed 150 pounds. Like, he had no clue. He was still a baby. So, but I agree with this. And not only that he's taking all this time to do this, but also that he has a witness for rebuttal and stuff. Like, it's just odd to me because you believe this is a taillight. This is where Hank will have a problem. I don't know if anybody knows who Garrett Wing is or have seen him talk about this. But when you consider, okay, let me talk about Garrett Wing first. In one of his lives, I think it was the one with Melanie Little, he had like this fake arm and he showed wounds to this fake like rubber arm or whatever. And like how that would be consistent with these whatever, bites, scratches, abrasions, whatever. So I would anticipate them being able to do that. The problem is that Hank was not able to do that. Like, Hank has this man up and he shows about the paint, you know, the positioning of these wounds. But one could argue that if you're just talking about the positioning and not the actual wounds themselves, this same exact positioning could happen. All you have to do is pull up somebody like training a dog, a police dog, with that thing on their arm and show that's exactly where dogs bite to try to pull you down.
So I sent you something that apparently that Ems just sent me from DB.
Where?
I sent it to your messenger.
Okay. That's literally exactly what I picture. Like what I've always pictured. Are these the bones, though, of a German Shepherd about 7 years old?
I don't know. She just sent me that.
I would want to know because this would be a really great graphic if so. But to go off of this, like, I would want to know that this is like, I don't know, not a Great Dane or whatever.
Right.
I also forgot about their little thumb toes. Their hands. I don't know if they're hands. I don't know if that's a hand or whatever. Do you call them hands? Or are they all feet? Like, I don't understand. They walk on all of them.
They're all feet. They're all paws.
Yeah, they have all 4 feet. So it's thumb. It's paw thumb, I guess.
The dew claw?
Yeah, it is a dew claw. Yeah, you're right.
That's fucking hilarious. You forgot about the dog's thumb toes.
Also, this view of the of this dog's teeth, like, make it look like it has human teeth, which is fucking terrifying. That's a really interesting graphic. But yeah, I would ask him if that's like.
You can show it if you want to show it so people know what you're talking about.
Oh, I can't. This computer doesn't do Messenger. I wonder if I'm logged into Twitter. Probably not, because I wiped this whole thing clean. And then I didn't even really need to because I bought a new computer. Yeah, no. Oh, wait. No, I don't want to sign up. What? No, I do not want to sign up. Get me out of here. No. Damn it. I'm not on Facebook either. There. I don't know why I did that. That arm picked up like over 18 notice. Yeah, probably. It do be a thumb toe. See? Can you pull it up or are you still on your phone?
No, my computer's just running really slow. It's not doing anything. And I was trying to restart it this morning, but I never got it done. So I'm kind of nervous to do anything.
I'm going to hit play and I'll try to figure it out. If I get locked out of my Twitter or something, well, I'll try to log into my Facebook.
DB got it from Reddit. DB got it from Reddit.
So
I thought
when you
DB
look
okay.
at this wound here,
Well, I can get it
you
from
said
Reddit.
that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions.
I think I can get on Discord here. Have him send it to my Discord. It's installing update 1 of 16.
And here
Em's put
there's
the link in chat if you wanna
associated
grab
with
that.
some punctate or point.
What? You're breaking up.
Yeah, see, Em's put the link in chat if you want to grab that.
How do I grab it? I can't click.
Never mind, that's fine. Give me a second. Yeah, it's not.
How come you
It's fine.
can and I cannot?
You can't do it from StreamYard. You have to
Well,
do it
how
from
can you?
YouTube.
Like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed.
Like
Is
what?
there anything about your methodology, something that stands out about these wounds?
Like even this one could be the thumb toe, the thumb paw, the paw thumb. That could be the paw thumb.
That you can say
Maybe.
to a reasonable degree of medical certainty that
Paw
these
thumb
are
here.
consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty. No.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these two
Dickhead, you said that that's what she said before and that you were looking at a transcript. You never showed the transcript. So now I know you were lying.
scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines.
Exactly.
And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these not exact, these two linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed.
Really? Like, keep letting this say trial is annoying.
That opinion as well at the most recent hearings, didn't you?
No, I'm going to object to the worded use
So-
that's been done before.
Mr. Brennan worded differently.
Yeah, you've been saying this word over and 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 over.
Sorry?
Worded differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can you
approach?
just hold 1 second? Could you please turn the fan off? Joyce, is it okay if we turn over and off so we can hear better?
Oh, here we go. No, I'd rather really not die a heat stroke, but okay.
May I approach?
Yes.
You can fall off a cliff.
From your December hearing, page 100, line 5. When you were asked about that second wound in December, and I asked whether you changed your opinion from teeth to claws to just teeth. Once you asked specifically
Thank you,
about that
DB.
on page 100, line 5.
Thanks, DB. For anybody that wanted to see what we were talking about, this is the diagram. Oh, what did I just do? Okay. See? Oh. Pretty cool. DB, what I was asking was, like if we knew this was from a German Shepherd, but I can go read the Reddit thread. But yeah, this is kind of what I always pictured. And then John would obviously be standing, and so he would be like pulling his arm this way up while the dog was falling down that way. DB, that's literally, I was like, what? Why does his teeth look strange? I'm not sure if it's indeed a ghost dog or a ghost raccoon. German Shepherd bone images. I would want to know if this was like a German Shepherd about 7 years old. Damn it, what did I do? Okay. I can stand his ass.
Yes. But may I read it?
Sure, I'll read it with you.
Okay.
No.
I said I'm
Walk
not
from my
sure on the
shoulder.
second set.
With your
So-
germs.
This is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set.
Now I heard you say incisor. Why are you saying incisors again?
Just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder, and then the sentence, but I'm not sure on the second set.
I
So
love it so much.
this is the set that's just above the elbow. I said I'm not sure.
And then, sorry.
Oh, go ahead.
Are you done?
Oh. Yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark
so
here.
awkward
and
and weird. Like watch him move around. He's so bizarre. Like serial killer hiding in the bushes.
Mark, and then this
Bizarre.
mark here, and this mark here. So it appears that this is from upper, and these are from
Look at their
lower.
faces, bro.
That's
Like,
what I was
what is
referring
that?
to.
I can't.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards
Does anybody else feel like he's been asking the same question over and over and over and over and over again? I feel like we have not gotten to a new question. It's been hours.
teeth. Correct.
Well, it didn't seem like you were leaning. You said
Oh my
these were
God.
from the upper teeth. You
Yes.
said it matter of factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You were
Yes.
asked, what do you think? And you didn't say, well, not 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
Oh, he did just trip her up because she is saying that it's caused by a dog. She just doesn't know whether it's the teeth or the claws. He should just end there, but he's obviously not going to.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two are caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Like if they hesitate or you're wearing loose clothes and they can't get a good grip, or they're particularly not like attack dogs or police dogs.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell.
Mhm.
A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
Are you a dog?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
Why are you
It's
insisting?
possible if
Why is he insisting it's those two teeth? He is testifying.
that's the only part of the mouth or the jaw that actually touched the skin. If it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm?
Right here.
The fleshy
That's
part
exactly
of the
what
arm?
I'm asking. It's a question I've asked before.
Okay, well, that's not the
When
posterior.
you look at the other side of Mr.
I
O'Keefe's
think
arm,
that's exactly what I asked you. No, sir, you don't know what the fuck you're talking about.
Yes, there's an absence of wounds.
when a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can
You are
be
an
if
expert,
both
sir.
jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law.
I'm assuming when he says the inside of his arm, he's saying posterior, but like I'm assuming he means the medial side, like the part that's closest to his body.
Enforcement dog or domestic dog.
And
You
there's
know
a
that,
difference
don't you?
between those two dogs.
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes, and coincidentally, every single one of them lacks any wound to the underside of his arm.
Yeah.
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds.
I'm claiming
Yeah,
that
I'm sorry.
that's not what I'm claiming.
It can happen though.
As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the
That's our
dog's
opinion.
lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree
How
of
are we
medical
still
certainty
answering the same question?
whether or not this was caused by a tooth?
Objection, Your Honor.
I'm
No.
going to strike the first part. Why don't you ask the other?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, put that back up, please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual
Why does the lower jaw have to be clamped on there?
wounds. I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower
just
jaw
did.
caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds,
Begging you to
again,
move along.
is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be,
Well, do you have the
Specific.
opinion today? I'm getting the transcript for you, Dr. Russell.
thank
Do you
you.
have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth?
How many times in a row is she going to have to say she's striking that comment before she says she calls them up to sidebar or says, no more comments, Mr. Brennan, like she would the defense?
Teeth or claws?
Individually, no.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No,
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's two linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
Yeah, why are
If
you?
this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It would depend on what angle the dog attacked him. Like if that were true, if the dog was going this way, or the dog was going this way, or the dog was going straight up and down, it would make a difference, I would imagine.
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it?
Again,
Objection, Your Honor.
So there was a question with that, so I'm going to let that.
Again, Dr. Russell,
So if I ask a question with a shitty ass comment, then it's okay. What?
the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you come up with?
Visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did not.
measure them, did you actually take out a ruler, measure them, and document them as you studied
How would you take out a ruler and measure them in a picture?
these wounds? Did you go through that process during your methodology?
Honestly, the ME should have measured every single one of them.
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is,
Why would you
it's
think
only a
things?
photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same
100%.
thing, it would be quite obvious, doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you use the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with the car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
No, a differential diagnosis is I'm going to list all the things it could possibly be and then narrow it down if possible. But if you can't narrow it down, that's still a possibility. Her whole purpose wasn't to set out that it was not a car accident. Otherwise, she did testing about it that way.
That was the result of my differential diagnosis and my pattern recognition
So if you're-
methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to
Did
know
she
a little bit
exclude
about
it?
collisions, don't you?
Or injuries from
Very, yes, I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
or the injuries caused by a car collision. But also, I don't remember her saying is absolutely not caused by a car accident. But maybe I wasn't listening.
Actually, I disagree.
I
However,
think he's trying to
I've
just
treated
confuse it.
thousands of victims of motor.
What?
I think he's just trying to confuse her.
Yeah.
That's why he keeps jumping around from different testimonies to different testimonies to try to get her to slip up in any way possible so that
Yeah.
he could call her out on it.
Yeah, I feel like he's this entire time. I mean, we've been here for almost 2 hours now, and I feel like he's been asking all the same question over and over again.
Yeah, that's on like objection asked and answered.
Yeah, I don't hear anything
How
new.
much longer do we have to be tortured by Brennan?
Literally, he acts like the only person that said that part of these things had to be caused by a particular tooth is him.
Well, so I was thinking this when I was driving earlier. Him giving so much credence to her and spending so much time talking to her,
Mm-hmm.
I wonder how that helps him. But then I was like, well, I mean, the other side spent a ton of time talking to like Welcher and Burgess, but I'm just like, if you don't think it's a dog, and you think it's the car, I almost wonder, like, less is more, like make it so that the jury hears so much more about the car instead of this dog.
Right.
I don't know.
Now, you're arguing about specific teeth rather than it not being caused by a dog at all. Like, why not say, what about a coyote?
Why not use her? Why not use her to get her to say that it was the car instead of continuously talking? I think just saying the word dog over and over again, it's putting so much in the jury's mind about a dog. And yesterday when we started this, one of the things I was thinking was, does the jury even remember anything about a dog? Because I mean, they've only talked about it like twice in this trial.
Yeah, I remember Buchanan saying something, but like we didn't get what's her face from UC Davis or anything like that.
No.
So
We got Jen McCabe saying the dog wasn't there in the morning, and we got Bukaki saying that Chloe's now Cora. And I'm like, does the jury even understand why we care so much about a dog? And now I think like they're like, now we care a lot about a dog.
I was gonna say, if anything, he's made it more suspicious.
Yeah.
For
Okay.
a dog.
So you got, that's where I'm at. Like, I'm like, am I wrong on that? Like, because obviously the other side argues, with the people about it being a car, but I just feel like he's really brought forward this whole, it's a dog.
More so than the defense did. Like they offered it as a possibility. Like, this is how I can explain it, is they offered it as a possibility, and he seems to be considering it as the actual cause, and he's trying to make it so that it's not it, and they won't consider it. And it's like, probably thinking, thanks, Brian, now you confirmed to us it's a dog. Yeah, like that is what I'm thinking. I mean, this has drug on. I would expect as a juror in a case where the person's charged with running someone over and leaving them for dead, to have the defense talk for a really long time to the people that were dealing with that data, I would not be expecting the Commonwealth to be taking all this time talking to this lady about dog bites, which, like you said, I would be confused why we're even talking about this.
Right.
I'm trying to look. I have to go get my charger to look and see if. Well, I don't feel like it right now because I have to get my charger. I'm at 20%. But Sue O'Connell, I checked her just a little, not that long ago, and she didn't put anything really. She was arguing with people about something else. I don't even remember what it was. Unrelated to this. They're back now. Alessi, is that Hank? That looks like Hank's still at the podium. So yeah, I think she's still on cross. So like, my God.
Vehicle accidents and have seen the wound patterns that they come into the emergency room with. And however,
By a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for me.
Do you really
Quinn.
think?
I'm sorry, please.
Did you finish that answer, Dr.?
No,
She was
Did I
mid
cut you off?
bro.
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case,
Yes. Yes.
I didn't have a lot of information. That's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask.
No, she doesn't have to look at Jen McCabe's phone data or her witness statement saying, I hit him, bitch.
You. Are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Are you for real?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Hank, you
Do
idiot.
you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
From the Massachusetts State Police? Like Trooper Paul's training? Really?
In terms of accident and
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists.
He's not saying anything about
Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
Why
No,
was-
and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related
Seriously?
to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Yeah, so why are you
Yet,
asking?
yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion?
Yeah, because that's not outside her scope because she has seen injuries from collisions.
Yesterday?
That's far different than trying to reconstruct an accident.
Wounds are in my area of expertise. So yes, I am very
Yes, Carol.
comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors.
Have you
Yes.
studied that before you gave this
Studied.
opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at photographs.
And when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight?
No
Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Yeah. If you hold it the exact way that Welcher held it and you lean into the car as it's hitting you at 2 miles per hour.
Did you look at photographs of Miss Reed's broken taillight and see if where the brake was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
Oh, you mean
I did.
the whole
And
thing?
did you see that it matched up height-wise perfectly?
Close, yes.
You have really
Sounds like we need to have one of the dog experts just do a recreation of getting bit by a dog the same way they're saying this happened. And that would be the same as what his person's done.
respectfully, comprehension about the details of the car collision in this case, do you?
Because it didn't happen.
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022
How slow
at
it
about
was.
12:32 a.m., right around the time that you think these wounds happened?
She didn't say what
I
time
have-
it happened. When did she say that was the time she thought the wounds happened? Pretty sure she never said a time.
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
Oh,
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
basically
Several
not.
inches.
No, there wasn't.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you?
Trooper Paul said he never landed anywhere.
No,
There's no
he's still
evidence of
flying.
landing.
He's still just he's still out there after his pirouette. He's just
Yeah.
flying.
Get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Nope. No, you didn't. I've never seen a picture of anything other than the berm uncovered by someone else's foot. Otherwise, no, there was no visible grass under his body or in the yard at all. Absolutely not.
Not 2 inches of snow. The ground, the
Absolutely not.
cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass.
Have you
in
ever
the
looked
picture.
at?
No, you
Have you ever
didn't,
looked at
though.
Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at
I
the
don't.
pants?
I don't think he has that in evidence. I don't remember anybody testifying that it looked like he had landed on the ground. In fact, Buchanan, they weren't even allowed to say if that were grass stains, for sure. Also, this is really bothering me. And if I was the defense, the first thing I would be clearing up is this whole that I saw an area of grass because you didn't. You saw a part of the berm that they wiped away that admittedly they tried to make it look like that was where his body was, but it wasn't.
I don't know if I looked at the pants.
So
To
when you
tell
say you
the
didn't
truth.
see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pant photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were
Really, all she needs to look at is the hoodie. I don't know why she needs to look at the pants.
available at the hospital of his clothing that was on the floor.
Were
So she
part
could
of
see
the
that the dog
photographs that
dragged
were
him
available
around?
for your review and your
Whatever.
conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about
No.
something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as
So
possible?
let's, we'll come to side by Mr. Reed.
Yeah, we're tired of his attitude. I mean, it's outrageous.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
Oh,
I
my.
did not need to.
Did you?
No.
No, because I didn't need to.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris
Didn't
in
need
that
to.
area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the
They take terrible
ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Exactly. And neither did the medical examiner.
Do you know Mr. O'Keefe had other injuries
And she didn't visit the scene either.
other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds,
Well, the car didn't cause the head injury, so.
did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are the instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant
Hank, you have not provided evidence of that he was thrown in the air.
injuries, correct?
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that received injuries from broken plastic or broken glass in a car?
Yes, many times.
No, you didn't
And
prove
when
that
you've
either.
seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
Yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions, about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were
Hank doesn't know this either, so like I'm so confused why he's even doing this. He didn't even get his witnesses to testify to this stuff.
no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down. And so, yes, I used that and tried to put that in a scenario of his various positions. What could he have been standing, kneeling, sitting, lying down on the ground? I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
An object?
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
questions?
It wasn't
I'm sorry,
really documented well.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify?
I just want to use this opportunity to remind everyone that while Hank had his experts show that whatever weird way Hank's forearm and upper arm could have come in contact with a whole taillight, he did not show how that taillight breaking caused those injuries on that arm.
Identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian. Yes. Not as a medical expert.
Can I have Exhibit 74B, please? In your study, before you...
Now that I'm thinking about it, he was knocked out of that shoe, but he didn't have any injury to his foot either.
gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm. Were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that there was one shoe off. Correct.
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware. I have been aware of that. Yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat, there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be if the ground was frozen. If it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
You can take that down, please. Would there be any significance in your statement that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours.
Yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having a trouble
Okay,
understanding the
it's
question.
my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle. Yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken and missing pieces. Yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken? And considering this conclusion,
Yes.
did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
None at the time, but I expected that if there were a collision, that there would be pieces of the car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and timing?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken.
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be, I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we have
the vehicle parked, yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case, you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision. Do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case.
Oh, are you referring to what you've asked me previously about, did I hit him or something of that? What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020 Nightline docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact, a collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
Yeah, no. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, aren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have exhibit 147B, please?
Are we going to talk about all the unidentified DNA?
On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round
Tears? Does he mean tears?
holes in that
You're
fabric.
aware, aren't you?
He can't
That
differentiate that.
Those holes were
Those two
swabbed
words.
for traces of dog
Sleuthie.
DNA.
Oh, that's not an evidence, Hank. We know about the unidentified people. You didn't bring in that lady from UC Davis to tell us that it had been swabbed for dog DNA. And tell her they found pig DNA.
Okay, come on up.
Mr. Lessie, I'll hear you.
Thank you, Your Honor.
Is the witness there? Oh, outside the jury's presence. Is the witness there?
Mr. Brennan, can you remove? Oh, okay, it's being removed.
What is?
I don't know. I didn't hear him. I couldn't hear him. Somebody's chair pad.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA.
Yeah.
Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice.
Yeah.
He sounds pissed. He sounds like he's shaking. He's pissed.
And Bev's gonna be like, I disagree with you, Mr. Alessi. Let's
for
move
sure.
forward.
For sure.
A mistrial with prejudice. There has
I'm
been
surprised it took this
no mention in this trial of DNA
of a dog.
with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made, that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said,
I think he's referring to when he said to Dr. Russell that she or they or all of them were put on notice about going and like testing the dog also. And he
we're
never did provide proof of that.
going to, or we always intended to bring on rebuttal, Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened is, this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction.
And the defense shouldn't be forced now, because he decided to say that, to call Terry Kuhn from fucking California to come testify about that.
She's not gonna give two shits about this.
Well, I know. I do know that. But he did do it on purpose. I wonder if he's going to have the audacity to come up and say it was not intentional.
Of course he is.
You think?
Oh, God, yes.
You think he's actually going to say it wasn't intentional? Like he didn't think about it and then...
Well, yeah, he's going to be like, it's just it was a mishap. It was not intentional. We were just going over what evidence she had reviewed and what she had talked about. And, and
yeah,
that's
you're right. You're probably right. Oh, he's fucking pissed.
That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions.
They never are forced to suffer any consequences with Beverly.
Actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy,
I'm
the
shocked
only
she's
remedy
interrupting him.
is a mistrial with prejudice.
Pause it real quick. Sometimes I do forget that we do have people watching us that have never actually seen the other trial, so they have no fucking idea what we're talking about. So what happened was that they had swabbed 2 parts of the sweatshirt, or took 2 swabs of the sweatshirt.
Of like the
And-
arm, but nobody said exactly where.
Nobody knows where, just 2 swabs of the sweatshirt. They sent those swabs to UC Davis, and a lady named Terry Kuhn, testified in the first trial that her lab essentially tries to find animal DNA, and they have like a set amount of animals that they look through, and that they did not find dog DNA, but they did find pig DNA. So
She also
that
discussed the things that would stop her from being able to find it or whatever. And like one of them was dirt, one of them was blood, one of them, I forget all of the specific things. I know dirt and blood was 2 of them, but things
Right.
that would
And then-
hinder it. But also she didn't take the swabs. Like they didn't
she
send
did
her.
not take the swabs. She does not have any proof of where the swabs were taken or anything along those lines. So this is where Bob's owl pig theory came in, because he was attacked by an owl like Michael Peterson's wife, but then there was pig DNA. So then there was an owl pig. That's if you guys ever hear us talk about owl pigs, that's why. And then number 2 is when Jackson came up to cross Terry Kuhn, he was talking to her about like dog traits. Like, what are dog traits made out of? Dog bones, rawhide bones, this, that, and the other. You know, how much, pig is in any of that. So if there might not be dog DNA, but if the dog is eating anything to do with like a pig treat or pig ear, then could the pig DNA come transfer over? Well, so this trial, the issue with bringing this up is that Brennan, we're now on the defense's case in chief. Brennan, on his case in chief, brought up nothing to do with swabbing the arm and sending it to UC Davis to have it tested for animal DNA. So there's zero foundation for him to be able to bring this up. And now he brings it up in front of the jury to say, hey, did you know when you were doing your evaluations of these dog bites, did you take into consideration that there was no dog DNA on the sweatshirt? So, well, there's no foundation for that. Nobody's planned for that. There's no witnesses that are stating that. So you can't just say that in front of the jury and not expect that the jury's going to have some form of prejudice when there's no foundation for him to be able to actually bring in this DNA, because he made the decision not to call Terry Kuhn or to talk about the fact that what's her name from the lab took the swabs and sent them, because you'd have a whole different set of witnesses for the defense to be able to come in and say, hey, this is what happened, or they'd have a line of questioning that they could discredit these people, so on and so forth. But Brennan just in front of the jury says there's no dog DNA on the sweatshirt with no factual basis behind it. And legally, you can't do that without foundation.
And it's her fault, though, because she's been letting him testify this entire time to things.
Yes.
And so,
he's
I mean, it's her
cross,
fault.
so he can lead, which means he can state things versus just asking the question. But he is. I mean, if you go back and do like a word count on what Brennan has said versus what the witness has said, I mean, he's talked more. Her answer to this is going to be, I will give the jury the instruction that what lawyers say is not evidence.
Yeah, you're probably right.
I'll bet money on it.
That's not enough, though.
It's not, but that's what she's going to say.
Well,
I could be wrong, but that's my guess.
well, it's still going on. So, like, she did not declare a mistrial.
Right.
Mr. Brennan.
Let's see. What do you have to say for yourself, you little piece of shit?
Here's a little post-it.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's a
You don't have any evidence. You've not shown any evidence that there was no dog DNA.
essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense
What?
creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury.
That evidence has to be in evidence.
Let's be clear. The
That they're
defense
trying to
is
say.
on
This is you,
notice
fucking idiot.
that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going
My
to
God.
propose theories that we thought were unsubstantiated, we would do so in rebuttal.
Well, this is not rebuttal, you piece
It
of
is
shit.
clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is
What is he talking about? These witnesses are on the witness list. What witnesses?
complete in the historical record of this case. Dr. Russell herself
Okay, but the jury
testified
doesn't
on
have
December
that.
12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it. She discounted it. She created false theories about the potential destruction of it. But
Oh.
she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient. It might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not.
I don't know what they portrayed to the jury yesterday, but also he's not saying that it was an accident or anything like that. He's saying, by God, I did it. I did it intentionally and I'm allowed to do it.
Not improper. It's not unconstitutional. It's not irrelevant. It's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear.
Well, then why didn't you call Terry Coon? Why didn't you call them to testify to that then?
Superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are
I'm going to walk
important and not
outside
important.
in circles.
Because
I'll be
they
right back.
chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond.
Okay, so did you not bring it up in your case in chief because it was hurtful to you or something? Like what is even happening?
Why not just bring it up on rebuttal? Why not
Right,
just
why
bring it
didn't you
up on
just bring it
rebuttal?
up on rebuttal?
Just bring fucking Terry Coon in for your rebuttal then, sir. Like,
100%.
shut the fuck up, you piece of shit.
100%. Exactly. Now I'm actually
On the
going to
scope
go
of
walk.
direct-
I'm going to go pace outside. I'll be back.
This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you,
Mr.
Your Honor.
Wilson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds to the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
I have 30 seconds.
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 12th, 2024 transcript. I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more, but that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi, wholly.
All right, thank you. We'll give everybody a half an hour.
Breaks his nose.
All right.
Sleuthie will fast forward us when she's done pacing and walking holes in her yard. Yeah, at a December hearing, they had her testify where he was questioning her. So he's saying it was brought up for quote unquote this trial.
No, that's not in front of the jury. That's entirely different. And that was probably allowed with the thought that you were going to present Terry soon. Exactly.
Alessi said those words not in the first trial, at a December hearing going into this trial.
Okay.
No, Joanna, absolutely not.
You are unmuted.
Please be seated for the session.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
You bitch.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh, yes, but not right now. They're on their way. All right. Do you have enough?
I'll work around it.
Okay.
I'll work around it.
Your Honor, I would object to being done outside the jury, that it should be done like I've had to do with several witnesses in front of the jury.
Okay. If that's what the defense wants. Are you sure, Mr. Alessi?
Oh, wait, I'm sorry, let me confirm with my. Yeah, okay. I am going to, yes, Your Honor, we are going to.
Oh, dear.
Thank you, Your Honor.
Okay.
You're on the way, Your Honor.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Is are the lunches here? Probably not. Okay. Are they still over there? How long they are?
Did you start yet, or can you turn?
If they're downstairs on their way up, I don't want to stop them.
I could do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, we're subject to whatever Your Honor does. Based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35 to finish up whatever redirect that I have, if that affects Your Honor's scheduling for the jury.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it downstairs.
All right, we'll do this now.
Be quick.
Okay?
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
Yes. Can we turn the fan off over here, Tony, please? Thank you.
Dr. Russell, did you ever review and receive that document from the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard. I disagree with his assessment.
Thank you. Yeah. All right, I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it and I was not allowed to pursue questioning. So I do not believe under the standards that's been set in this trial that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they open their own door to vouch for their own credibility and suggest that they're the only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Leslie?
Thank you, Your Honor. My response is this. I'll give two quick examples. Dr. Welcher, Trooper Paul, Dr. Squirty Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Squirty Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Paul.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark.
Okay. All right, thank you.
What is
Hunter.
she not letting in? I missed that. I don't know what she's not letting in. Sleuthie, we need you.
Objection. Where are we? Is it in evidence now?
It's not yet. It will be.
Okay.
Something Hank wanted, but I didn't hear what. Welcher's report?
The DNA. It's not, right?
It is not.
Okay.
Is there a question?
Yes, it's open. I denied the motion and allowed the line of inquiry.
Walsh report? You mean Welcher? She's not letting in the report of MD Walsh's opinion and her not looking at it. No Walsh, because of some same logic when defense couldn't cross on Trooper Paul or Squirty Bello. Okay. So no Walsh. Yeah, no, he's not an MD. I didn't know if it was who we were talking about. I missed it. I walked away for a second and came back, and all of a sudden she's denying something. So I was like, wait, what?
Yeah, it was Wall.
Bunch of taint. So much taint going on.
And basically and I agree, it was kind of should have been an easy decision that she didn't let the defense ask Welcher about Trooper Paul's or Dr. Squirty Bello's reports or whatever, despite the fact that he literally screenshots of them in his presentation. So yeah, no, they shouldn't be able to talk about. And also, Walsh didn't even testify yet.
Who's Walsh?
Walsh is, I believe, and I'm going to look right now. I believe he's their other medical examiner, the defense's.
The defense's medical examiner. We've not had a Walsh yet.
No.
She says, at least Bev saw that if she let it in after she denied the mistrial motion, it would show how biased she is. It would be grounds for appeal. Walsh is apparently an MD that she disagreed with. So
I don't have Walsh on my spreadsheet.
I missed the whole argument, so I don't even know what I don't even know what the argument was.
I can rewind.
I do not believe that foundation has been laid yet. can continue with this line of questioning.
Okay. Here.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation.
Dr. Walsh's opinion.
So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could we do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh, yes, but not right now. They're on their way. All right. Do you have enough?
I'll work around it.
Okay.
I'll work around it.
Okay, fast forward to when she's on the stand.
I'll be done very quickly, so I'll make that decision.
Did you start yet or can you?
I just, if they're downstairs on their way up, I don't want to stop them. I just didn't want to stop them if they were on their.
During your review, the defense provided you materials. Did they provide you the report of John C.
Oh, so now we're doing the voir dire.
Yes.
Walsh, MD,
Which I missed.
Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here, Tony, please? Thank you.
Dr. Russell, did you ever review or receive that document from the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard. I disagree with his assessment.
Thank you. Or I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it and I was not allowed to pursue questioning. So I do not believe under the standards that's been set in this trial that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Leslie?
Thank you, Your Honor. My response is this. I'll give two quick examples. Dr. Welcher, Trooper Paul, Dr. Squirty Bell. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Squirty Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Paul.
I'm not letting it in.
Thank you.
All right, I'm not letting it in
Okay.
after that. Mr.
All
Brennan.
right,
So you
perfect.
can mark the
Thank you.
report if you want, but for that reason, I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark it.
Okay. All right, thank you, Hunter.
I love how she says for the reasons stated by the Commonwealth. No, ma'am. For the reasons the defense stated, you're not going to let it in.
Well, I think what she's saying there is that you're trying to bring it in for XYZ, and I'm denying it because you're trying to bring it in for XYZ, and that's not going to work.
Oh, so like on his lunch, he can think of a different reason.
Maybe, yeah. Like if you want to try something else, let me know. But
Ugh.
we know that we have. I think we're supposed to have Lucky today. We're supposed to have Nick
Rena?
Barros
And Karina Kolakithis.
and Karina Kulakifas today. So we'll see. See if we get there.
And I saw some tea about Karina Kolakithis, but I would rather hear it if it's true, because you don't ever know.
She'll be like, We're never getting to anyone else ever.
Literally.
Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen.
on the ground. His face was redacted, and there was.
Oh,
some
that one. Yes.
Remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce, or?
You
No, I
should.
was just answering questions.
You
Okay.
idiot.
You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with a car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body brakes, do you have any studies about the frequency or the likelihood of lower body brakes in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it. And I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the
We don't know who's
collision
real ones.
or impact as the cause of those wounds?
Well, I considered that. However, He had, my understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
I wish she'd say, the one thing I didn't hear is, was any DNA on the pieces that were broken?
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve. Yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it. Excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
Left? What a fucking idiot. He's a dumbass. It's not the left.
Yes.
Idiot.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So yes, I am aware that there were some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion?
Objection, Your Honor.
What a trash bag.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, and giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA,
That's correct.
and there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog with John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection sustained. Can I ask it differently?
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. If you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA. Yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm sorry.
Sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, and you wonder why, and you want to know, was the test done correctly? Was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with, and then of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scortabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
You haven't even put on that evidence. And if the Commonwealth would have, that their own expert would have said why it could have not been come back as dog. This is so drug out. My God.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle.
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Okay.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision. I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
I have no further questions.
Mr. Alessi?
Thank you, Your Honor.
Okay.
Ermagerd, it's over.
Okay.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolk, you could go back, can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolk, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolk, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit, well, anatomically a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Goosie.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies and as part of your answer. Do you recall that discussion with Mr. Brennan?
Yes.
Do those, and are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes, so one of them was by Dr. DeMunick, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties
So
of
if we
the
could just-
authors.
I'm sorry to interrupt you, Dr. Russell.
I'm
Have you
sorry.
finished?
The specialties of the authors, yes.
If we could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, for Madam Court Reporter, exhibits marked for identification PPP and QQQ.
Right.
And I'll start with PPP if I could, please.
Or like mind your P's and Q's, Hank.
Thank you, Madam Court Reporter. May I present PPP to the, thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. DeMunick?
Yes,
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? You recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
yes,
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxilla is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite in which the dog can lock onto his prey. The tremendous force of the bite, muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay.
Sure. 298. If I could return this to Madam Court Reporter and please request Exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Demunic study, can you please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child. And they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the morphology of dog bite injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes,
How is it relevant?
because if not all the teeth impact, then you get a partial bite. You get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting, curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, can you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items, if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay, so we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow. And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any, is textiles mean clothing?
Yes, and I thought you meant in this
decedent-
article, but yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt
Please continue.
or sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
A lot of this article is relevant, and I don't know if you want to keep.
I don't want to
keep on
keep
reading.
reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that said.
Thank you.
Yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell.
Mhm.
Madam Court Reporter. So do those studies, the Demunic and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
So as to the form, Mr. Leslie.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies' methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. And described some individuals, but they looked at the overall pattern to make recommendations.
Was the overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypotheses was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or?
Well, I'd like to
pain?
give you an example of what you used here in this case as the application of that.
Well, okay, so I'm just describing the overall process, because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong. And so you have to allow for other information. And so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression. But I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
Sleuthie's like, I'm gonna sit outside. I'm ready for a new witness. Me too. I'm ready for a new witness. Sleuthie can't fast forward from outside. So she's like, son of a bitch. I had to go to sidebar as soon as I walked outside. If the pictures were taken after death, his body won't be flexible to position in different positions, right? It depends on how soon after death. Remember, they just warmed him up, so he was cold. Objection, Your Honor. Here you go. Where is it? Here it is.
Your Honor. Your Honor.
Look, I made my own ceiling fan one. So you'll never know. It's a trick.
What if any? What if any?
What if any of them? What if any of them? Here you go. There's Lassie. This was one of my favorites too. So Colin Halbert falls down. This is how he falls. They're on a sidebar, and so you're not there fast forwarding. So I'm just entertaining myself. There's this one that Arna made yesterday. Because
I hooks up my plans and my day every day. Here we go. I love this one.
May I have a moment, Your Honor?
Yes.
Thank you.
All right, Alessia, I love you, but let's go. Get it done. Let's let her go back to Cali. She's like, going.
Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation that what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Woke, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his that would be toward the back of that slide presentation, probably around 130-ish, 120. That's it, yes. And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? Lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here. What is the likelihood of there being any fracture to any bone?
Objection.
Sustained in that form.
Do you have an opinion based upon a reasonable degree of medical certainty as to whether there would be any fracture to any bone?
I believe that there is a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scortibello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scortibello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her or lunch?
All right, Jurors, I'm going to send you out for lunch, okay? We'll see you too. Yes. Come on up.
They haven't had lunch? We're still not even at lunch? I thought they already had lunch. I thought Jimmy John's was already there. Oh, God. dumb. It's only lunch. I know that's what I'm saying. Do you want me to switch it to my stream? I'm just sitting here. I can easily switch it so you don't have to keep going back and forth. Oh, we're going back down anyway, so.
Oh, I came in for nothing. I came in for nothing. What's it going to take to allow me to just be tan?
Nothing. You're gonna have to just be pasty forever. That's it. It's been
Nope, that's not an option. I don't
Punk
want
has
to look like tan.
decided you do not get to tan.
My word.
He said the word lunch and Bev couldn't agree fast enough. She's like, lunch, you say? My liquid lunch has been delivered? Thank you, Mr. Alessi.
Goes back to session, you may be seated.
God, let her go home. Both of you guys at this point. Just let her go. You're caught up now. Lunch just got over.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities. And to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee. And I looked underneath of that area very carefully on the photograph, and there was nothing, no injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
I have no further questions at this time, Your Honor.
Oh, okay. Brennan?
Did she just say, oh, okay?
Could I inquire about scope?
See what's that part.
Oh, Jesus, fuck. Sleuthie, we got a sidebar. Look at Hank. Fuck Upu. Fuck Upu. She's gonna come to fast forward. She's gonna come to fast forward, and he's gonna be done with the sidebar.
Yana. Yana.
Here, since they didn't give it to us, I'll give you guys the. shit. Is that Bev's twin sitting with the family? No, she doesn't have a wig on. Her hair's more normal. And the bangs are in her eyes. Who's this? Oh, you guys can't see my mouse. Who's the media guy in the back that kind of looks fucking scary, actually. If you don't come in, they're never going to end the sidebar. They're only going to end it when you get up to walk inside. That's the only time the sidebar is going to end. You think he's just an extra? They hired him. They hired him to be there to fill the seats. Well, they get John's one night at the movies 20 years ago lady. She's filling seats again. Her husband. Where's Thomas? He needs to come get his wife. He's a seat filler. It's like so quiet. Come on, let's go. Come get your wife. Come get your wife, sir. And take this extra person with you. He's kind of scary. Good, I'm going to have to come in, hug. Yes, we do. We need a Sleuthie hug. I'm telling you, they're not going to end the sidebar until you get up. I think you're just typing that in hopes that they think that you're coming. And so...
No, I'm here.
We got the fucking van now. Damn. Even the camera guy was like, this sidebar's taking forever.
Oh, look at that bald spot.
Gosh. That's what he does with his nose all the time.
May I?
Yes.
Do another fucking line, Hank.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
Asked and answered.
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Lisi had you look at a couple
Attorney
of
Lisi?
case
Oh
files
my God.
from the Journal of Legal Medicine, let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question. So we're going to listen to the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alisi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alisi highlighted the parts he wanted you to read to the jury.
Yes, and I believe they were the same parts that I read last time.
Can we have Exhibit 1, please? Now, regarding the Munich article, that was a case study on the unfortunate death of a young girl, yes?
Yes,
Who was attacked by or bitten by up to 3 different dogs.
yes,
And it was a neck wound from which she bled.
yes,
Very, very unlike what you're looking at here.
yes. But that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes,
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
yes,
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. In the way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see 1 or 2 things that showed up what I think might be upper and lower. So it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There
Jesus
is nothing on
fucking
that
shut
wound that is
up.
consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So
I-
when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity. I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm
I'm-
asking you about it.
Yes, and I'm trying to explain so
Nope.
that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone,
There
on
were-
that wound.
Okay. There are no punctures on this arm that I see. However,
Fine.
again, the wounds don't have to have every single characteristic. It is it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However, in
I'm just asking you the question, Dr. Russell.
So you can maybe ask her.
Specifically, this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realized that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alisi had you read, that is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the, no, I don't agree.
Okay. I move to introduce this as an exhibit, please.
Mr. Leslie?
Is it 210?
In the other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Alessi.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do
Do you
that.
see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast
You're the
was
one who
the
asked for
defendant's
that.
Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it.
Trooper
Where
Paul
did
did.
that number
Trooper
committed
Paul.
to or derive from?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor, so in the ER, I've treated thousands of motor vehicle accident cases, and most of the time I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alisi, and that's why I'm pressing you on these issues.
Sustained.
Do you know, you don't
No fucking
know
commentary,
the
Brennan.
movement
Shut up.
of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there, to give that type of information, are you?
You were the
I
one who
wasn't asked
asked
to
her.
give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about with these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event.
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr.
Is
Brennan,
that true?
Bullshit.
I have no details about the collision.
About what happened during the collision. You have no details about the body movement, the placement, the speed. You don't have any details that you know of other than what was told to you, correct?
Sustained.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise. It depends on the location. It depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone
It's for pain, not to
in the
prevent
cold
a
winter
fucking
on the
bruise.
front yard
God.
on the dirt and was being covered by snow, sub 32 degrees,
Oh my God.
and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me
Ice is for swelling.
That's what I
to
said.
explain?
It's nothing to
Okay,
do with
yes.
bruising.
So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume
He's going to say, well, he was outside and he never went inside. So he did have immediate coldness to the area. It was snowing.
weather is so cold that the cell phone battery on someone's iPhone begins to
What does the cell phone battery got to do with him?
plummet regularly in degrees.
I have
From-
no idea.
Yeah.
The objection system.
Kind of ridiculous, Hank.
When you came to your
I'm desperate.
conclusion, considering what you see in this picture, and Attorney Alisi was asking you about fragments from a broken taillight. Did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Oh, so
Sustained.
we're saying that what Karen said is 100% true?
Finally, Dr. Russell, you said during your differential diagnosis, you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor.
I'm going to allow that.
Would you like me to ask that again, Dr. Russell?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Objection.
Sustained.
You don't know what his scope and practice is, do you?
No, but I always look at where the person works that writes a report in terms of physicians and what their possible experiences are. You know, do they work in a medical examiner's office in Alaska or, Hawaii or a big city or a little town? I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture, bite wounds.
She already said
and
that
thus are highly unlikely to be the result of an animal bite attack.
She already said that there's no punctures. She also said that they were shallow bites, which you're not taking into account right now. Like maybe a dog that's not necessarily trying to attack you, one that's hesitant to actually bite people, since that's not their job.
The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
Also, who's to say that Walsh is more qualified than her? Like, you're just implying that he is.
I did.
You didn't put him on the stand.
However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions. Thank you.
Oh, thank God. Oh, my God. Even she's like, what? Can I go home now? Alessi, don't.
Dr. Russell, there were questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, you mentioned a methodology in connection with them. in pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained is to the form.
Dr. Russell, what is the purpose? Let's just start with the Demunic article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
So just a couple minutes ago, Jess Machado, which I guess she's in there, she said that was such an odd, she said jury check. So there's 18 people. This was 17 minutes ago. 1, looking at the screen. 2, arms crossed with annoyed look. 3, looking extremely bored. 4, head going back and forth between parties. 5, looking at the notes of the juror on the side of him. 6, I can't see this juror. 7, taking notes. 8, staring at Karen Reed. 9, note taking. 10, looking down at her notes. 11, looking at Alessi. 12, looking across the room. 13, expressionless and void of emotion. 14, lifting his head to look at Russell. 15, taking notes. 16, head tilted back into the side, chewing gum. Why is he or she allowed to chew gum? 17, sitting straight up, looking back and forth. 18, taking notes. And then she said that
probably
was
not really chewing gum. They're probably just pretending just to do something else with their life.
maybe. So then she said that was such an odd move. Brennan asked a question of Dr. Russell. As she responded, Brennan left the podium and sat down in his seat. Russell was still talking, but he disregarded it. It was weird, especially when Brennan got to his seat, which is just maybe 5 feet in front of the witness stand. I noticed Karen Reed shaking her head when he did this.
Did we see that?
No. We rarely ever get to see the attorneys.
Wow, that's weird.
And then she said, this was 3 minutes ago. We are at a sidebar. I feel as if a random person who had no knowledge of this case looked over at the bench, they would simply assume Karen Reed is an attorney and not a defendant. She dresses like the attorneys. She pays the same attention and speaks amongst them as if she is one of them. Only thing she doesn't do is speak directly to the judge. 2 minutes ago, I can hear Canoni, who is speaking loudly. Paul O'Keefe is sitting in front of me, and he noticed as well. Motioned to the man sitting on the side of him, who is also now looking at the sidebar.
Ooh.
And then 14 seconds ago, well, we are finally done with Dr. Russell.
Russell made a funny face when
was
Brennan was done.
Dude, the elephant trunk lady made a fucked up face. She rolled her eyes at Dr. Russell as Russell walked away. I just commented on it and said I would be reporting her. Fuck that. How rude. Does she not realize that she's on TV? Like, give me a break. You got to know you're on TV. Rude.
to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician
I
to
saw
look
that
for.
too, Joanna.
In terms of Attorney Brennan asked you, and so now with regard to the Pollock article, in terms of the Pollock article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollock speak to that?
He does.
And what does Pollock say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those are, and if there was material or textiles or fabric that were in between the bite and the skin. And there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh. May I approach, Your Honor?
Okay.
Nicholas Barrows is next.
Did you show Mr. Brennan?
He's the one who gave me it.
Okay. I didn't know what you had.
Yes, thank you. So may I hand to the witness?
Yes.
May I stand here, Your Honor?
Yes.
Thank you.
Just step back a little
Yes,
bit.
Yep. Step back a second. Dr. Russell, what I would like to do is to give the jury a fair
Objection.
I'll withdraw it.
Objection to commentary, and I'd like to be heard.
Why don't you bring the report?
Seriously, Brennan? He objects to the. First of all, you're not supposed to be stating the basis of your objections, you asshole. You've been doing it this entire.
Never get in trouble. Just let this woman go home.
May I proceed, Your Honor?
Yes.
Thank you. Dr. Russell, I am rehanding you this letter with from Dr. Walsh. And what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank you.
Watch her.
I'm going
Watch
to
her.
have this marked for identification.
Watch her.
Thank you.
You want it on a cone or in a bowl? Cone. Watch her. Oh wait, maybe it was. Oh, it was when she left earlier.
Yeah, I think so. She was standing up, wasn't she?
Yes. Why didn't you do it
And
again? Did
the
somebody tell you they
next
saw you on
witness
TV,
is
bitch?
Who's the next witness?
Nicholas Barrows.
Yes, just tell me the name because I need to know whether we need to go to sidebar first. Okay, thank you.
Who do we need to go to sidebar before they speak? Is that Karina Kolakithis?
Probably.
The rumor is she's got her lawyer with her. She'll have her lawyer with her today. Skippy.
I do.
He does.
Good afternoon.
Look at that sharp outfit.
Man, he looking good.
He does look
You
good.
look
Mr. Jackson,
fine,
you are
sir.
all set.
I
Thank
love
you,
that.
Your Honor. Good afternoon,
I
sir. How are
love
you?
the gray and the
afternoon,
white, the gray and the white and the blue tie. I love it.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barrows, Barros,
And where do you currently work?
the town of Dayton, Dayton Police Department,
How long have you worked for the Dayton Police Department, sir?
since 2011.
And what's your position there currently?
Currently, I'm a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dayton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings. as a police officer and as a supervisor.
When did you get your bachelor's
To be clear, he's more educated than Burgess.
degree?
I'm just saying.
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation,
To an extent.
witness interviews?
No, that would be the detective bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature.
Correct.
All right. As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are in the police academy. We're told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later
Correct.
that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have any, you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Did you know any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dighton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual.
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to
Yes.
location?
Yes.
At some point after you received that first call, did you receive any other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dighton.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger.
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barros, did you, I don't want the address, cameras are rolling. Did you respond specifically to a residence in the city of Dighton?
Yes,
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dighton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the
Okay.
name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon, he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
30 is when he first called me and said that they were coming to Dighton to retrieve a vehicle that that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Do you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever.
None.
Same with Trooper Proctor.
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes. Once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works?
The whole works.
He's like so impressed with him.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there. And I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between, longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that
Yep.
description is?
There was, it was damaged. The taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you would call it?
The piece was about maybe this big,
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches. or
And
so.
how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere
Okay.
in there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight,
Of what?
the Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different about this photo?
Damn.
That taillight is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Objection.
Sustained. Ask it differently, Mr. Johnson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two.
Sounds to me like the size and shape that he was describing would kind of be similar to the piece that's never been found. Now, I'm assuming that right now he's fixing to point out exactly the spot where the piece was missing, but an officer being on the stand that was there before the vehicle was towed, saying that that is absolutely not what it looked like when he saw it in the driveway, should be huge.
Displays, one monitor directly in front of you and
I
one
am
to your right. If you could use the one to your right, it's a little easier on the jurors.
I even came in from Tandon for this. I'm just saying.
Describe what's different about that taillight.
Please do.
Can you see that? So this area was intact. This is
This area, this whole area was intact. This is what he's sounding like he was getting ready to say was not there. And if you remember when Welcher did his experiment, he didn't really hit this part. He hit all this.
Yes.
Wow.
what I saw was missing.
Holy shit, right here.
May I approach?
Yes.
Oh my God. And to be honest, at the last trial, I found him the most credible. Him and the guy that did the extrapolation.
Oh, yeah.
And also the Kolakithises.
Yeah.
And to be honest, also the Camaranos. So.
Lolly called him last trial.
Yeah. But from what I understand, the defense hadn't really talked.
As a defense witness, I think is very impactful right this second. So.
Yeah. They, from what I understand, they last trial, because like people were saying the report, because we have the report. The report said there was a that Proctor, see, what was interesting to me was that Proctor called, hadn't seen the taillight yet, was just going off of Jen McCabe saying that supposedly a piece was missing. But when he testified last trial, he said that it was cracked and there was a piece missing, but it wasn't completely damaged. But apparently, from how I understand from others, is that the defense didn't do this, like put up a picture of it and say, is this what it looked like? Because they did not know what he was going to say. And now they do. Exactly, Kat. I am in shock. I am absolutely in shock. And he dressed even better. I don't remember what he wore last year.
I don't know, but he looks fancy today.
Kim, do you know, or do you want us to rewind? Yeah, I think they talked to him since then. Because last year, everyone was saying, like, why didn't they show him a picture, blah, 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 blah. And it makes sense. Like, even if they knew that it wasn't damaged, it's good practice, like, not to then get up and be like, having no clue what he's going to say. I think this should be really impactful. It should have been enough that he said it last year, but it was not the same because they did not show. He said that it was cracked and there was a piece missing, but it wasn't completely damaged. But he did not testify the way he just did, where he said that absolutely is not what it looked like in the driveway. Oh, Hank is so fucked. So now is Hank going to come up here and try to discredit a police officer?
100.
I mean, this right here says to me, Proctor broke that taillight, and he saw that a piece was missing. That could have happened earlier when she was backing out of the driveway. See, what people fail to understand is that even when ARCA testified about this, the damage to the taillight as we see it in the Sally port, no, that's not possible with her backing into his car. The total destruction of the vehicle or of the taillight. Yeah, Joanna. Well, and the tow truck guy is on the witness list this year for the defense. The guy that I've posted his him on the phone with somebody saying that it was not damaged.
It wasn't damaged. Yeah. So if they put him on too, and he also said that it wasn't damaged. Oh, jeez.
This also discredits Jennifer McCabe and Carrie Roberts, who both saw her vehicle prior to Nicholas Barrows and looked at a photo of the taillight in the Sally port and said that was consistent with what they saw. Well, the taillight didn't gather more light. Like, it didn't gather additional pieces of plastic from the time they saw it to the time this guy saw it.
Right. Well, then you're also going to throwing Karina Kolakifas up there is going to destroy Jen anyway. So
that's what I'm hearing. I hope we get to them today. It's 3:00. We might be able to get to her.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
For sure.
Do you believe you would remember if the taillight, well, let me ask it a different way.
Would you say that is absolutely not all the pieces that were missing when I saw it? If there was a chance that that red part of that taillight was actually gone? Good on you. They're calling him Officer Truth Daddy.
The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
No, fuck you, Hank. You're done.
We can take this down. As you sit here and recall back to your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably
not 1 minute.
20 minutes or so.
Yeah, that's a long ass time.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the...
Me too. Lawyer, 3 minutes ago, why are we here?
phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have.
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
Wait, why can't he use his testimony from last year?
He didn't ask enough questions to get there.
That or it's, I don't know, is it cumulative? Because he just testified to that too? I don't know.
Scene.
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen? Like, for instance, the SUV is taken away?
When I clear from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Shut up. Bitch, is Jennifer McCabe's sister there today?
I didn't see her.
Oh, now we got to look for her. Next time they pan out. We had all those sidebars we could have looked for, and I didn't even realize it because I wouldn't expect her to be there. Dee Dee, the one that did the timeline. That's a little suspicious. Especially if what I've heard about what Karina's going to say is true, and she got her sister sitting there for Karina's testimony. We're not supposed to be suspicious of that. I can't even.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.
No.
The audacity in these motherfuckers.
I'd like to show you another exhibit, if I could. This is exhibit 105.
Joe Jack alone just said Sergeant Barrows just sunk the Commonwealth's battleship. Wow, I wasn't expecting that. Turtle Boy, how do you respond from this testimony if you're the Commonwealth? You try to discredit him. I don't know how they're going to do that, though.
Well, he's going to ask him, did you see Proctor or anybody from Massachusetts State Police or Canton Police break this taillight?
Well, that don't matter. You know why? You know why that doesn't matter? Because the defense isn't suggesting that they broke it there. They're suggesting that it was broken at the Sally Port, and this man was not at the Sally Port. Point blank period. Before that taillight was in the custody of Michael Proctor and Yuri Buchanan, there was a piece missing out of the side of it, not 75, 80% of the entire taillight. And then by the time photos were taken and search showed up, there was 75, 80% of the entire taillight gone.
Don't start it yet. Hold on.
This, I swear to God, we're not starting tomorrow until I figure out how to add the Jaws thing to.
I'll do it. I started working on it last night, but then I got so sidetracked with AI and I was making really funny.
Are you trying to make our thingy move like I asked?
That's how I ended up with the Jaws thing. And
oh my God, what a twisted rabbit hole you fell down.
I did. And so then I was making rat face Brennan with Jaws behind. I'll show you. Hold on. Don't start it yet because I want to. Richard just made a really good point, and I want to pull this up before we move on. But my computer's just so slow today. I don't know if I can do anything. I tried to restart it this morning, and it just didn't. It just didn't work.
Oh, we need to find that diagram that was done long ago after the last trial that was color coded so we can see that piece that he said was the only piece missing. I would like to know who found that piece. Was it Proctor? Because now I'm all the way in on the conspiracy with Proctor. It's like, did he bust it on his way inside the house and he took the piece? Was it cracked and he pulled a piece out? Are you still here?
Yeah, I wanted to show this. I'm just trying to let it load. Yeah, the taillight after the one chick puts it back together.
Yeah.
And what piece is missing?
Well, the piece that's missing is the clear piece in the center.
I had a better photo of it.
Yeah, that was like twisted up. Like I can't really tell what
Yeah. hold on.
orientation we're looking at. Yeah, that right there. Oh wait, but it's not put together. So the piece right there by your right hand, or yeah, there, that's the only piece that was missing. So all the other shit, but when she put it fully back together, that piece in the top left is the piece that was never found, I guess.
Yeah, I thought there was like a front angled one after she put it together that was much better than.
There should be. It should right there's one. There you go. So she found that piece.
It's like this piece that's missing right here.
No, it's the big clear piece up there at the top. Right there. All the
Well, this piece isn't there.
that all the way to the top. That's missing. It was clear or yellowish.
But he says something over here is what's missing.
Yeah, that whole piece there. It's not missing.
No, it's not missing.
So that's what I'm saying is the only piece that was missing is there. Now I just need to see that diagram that I'm thinking of that somebody made last year, because I'm wondering if that piece that was missing when he saw it in the driveway was found later by Proctor, or was it found by CERT? Oh dear.
This was what I ended up doing instead of making Sleuthies. Dun it, dun it.
And we have that, but still not my sound. And I could have used it about 67 billion times. That's Hank.
She wants it. She wants the Jaws theme song, and I was gonna go make it, and then
Surely we have better quality production than me playing it on my phone, because that's the next step.
But this is what I ended up doing. So that's Brennan with Jaws, because she wants Jaws. So I gave her Jaws.
Like,
All right.
what made AI make his ears like that is what I want to know.
Because I told him to make Brennan with a rat face.
Oh.
I said make Brennan with a rat face.
And it's
then,
funny they kept his ears.
And then it did.
And gave him textured ears.
Well, no, I have other ones that actually he actually had. It's like a rat head. And then I was like, oh, that doesn't look enough like Brennan. So I needed to make like that. And then we were talking about the Jaws thing. So I was like, can you put a great white shark in with Brennan with his rat face? This is what I got.
Oh my God.
And then it was time for dinner and I couldn't play anymore and I didn't do it. But this was why you have no Jaws theme. Just FYI. Because this is what I did instead.
Well, I want to say that I'm very sad, but also I do love this. Although, like, this is far too rugged and handsome looking to be Hank.
That's what I think it was Indiana Girl said in chat. It was like, nah, that's not going to work. Well, so I don't even know if I can pull up the other one now because I think this is the only one I downloaded to send to you. Let me see if I can.
Oh, I guess he's on cross already?
Oh, probably. All right, we can go back to it. I just wanted to show you that. I wanted to look at the Richard had made the point about the tail light, and I wanted to look at it. There you go.
Federo said 13 minutes ago, the defense decision not to call Michael Proctor now makes sense, and Brennan's decision not to call him looks devastating.
Also, why it's important
Do you
that they
recognize this scene generally?
I do.
Bro, literally, like, I wouldn't be surprised if half of Massachusetts was outside to cheer for him once he walks out of here. If people could get there fast enough, I bet you they would.
Oh, yeah.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Mm-hmm,
Sure you see some vehicles in that still shot of the video.
Yeah, we see
I do.
Describe what you see.
That tow truck is Diamond Towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
Yep.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we play this video?
Yes.
Thank you, Your Honor. Can you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area. This area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
And it looks like
look
it's
clear?
missing
Is
that
that-
piece that he said was missing right there.
It's shining red.
Yeah, it sure is.
Looks clear.
The portion that is intact, does that appear to be brighter red?
Yep.
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Absolutely not.
Lights, please. Thank you.
Thank you.
What are you going to try to do now, you smarmy little piece of shit? Look at him
Good
looking
afternoon, sir.
Good afternoon.
at you.
Have we met before?
We have not.
Don't
You still
plan on
work
ever
in
meeting him
Dayton?
again.
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Mhm.
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene
Yes.
because it's your jurisdiction.
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it.
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
Yeah, you
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
They were in the
Ah,
house or outside of the house when you got there?
They were outside in a pickup.
more truth. When he arrived, they were already there by themselves, sitting in the pickup truck.
truck.
Did you see them get out of the pickup truck after you got there?
They got out after I
You little bitch. That doesn't mean that they didn't get out before he got there.
identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
You were
Did
right,
see them
Tate.
manipulate in
Mhm.
any way that rear taillight of the defendant's Lexus?
I
No
did
one
not.
believes
Did
you
you see them
anymore.
do
Hank.
anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house.
What do you mean by spoke to me?
After they introduced you, you introduced yourself to them, they went into the Reed house,
Yes.
and then they came out.
They came out much later.
And that vehicle was towed.
Correct.
You had no time from when you got there until you
He's like, bro, what are you getting at? Like, what are you even getting at?
left. Did you see anybody from the state police in any way tamper
I
with
don't.
that vehicle, did you?
Mav, I don't think that they hadn't broken it yet. I think they did pull that piece off there. To be honest, if I'm being totally honest, they were there before he was. They were sitting in the truck. They didn't take any photos of the taillight. They then happen to get it in their custody. They bring it back to Canton, and all of a sudden the entire fucking thing is gone. Give me a break. Oh, Proctor figures. Yeah, all right. Makes perfect sense. The piece that the only piece this guy saw missing when he saw it at Karen Reed's house was a piece that was found then by Trooper Michael Proctor. Who'da thunk it? I hope there's bigger, I won't say riots, but you know what I mean.
Oh, yes.
When the vehicle was towed, do you know how long it took to take the vehicle from Dayton back to Canton?
How long?
Yes.
Think cost long?
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
Don't even. This was Michael Proctor and Yuri Buchanan's case. Did either of them get that specific? Did they take any photographs before they towed it? This man was simply there because he had to call a tow truck because Proctor is too stupid and incompetent to do it himself.
Damage.
I could have.
You could have gone into detail about the width of the damage.
Why would he do that? It wasn't his case.
I could have.
You could have taken photographs of the damage if you wanted to.
Yeah, so could have Michael Proctor. So could have Yuri Buchanan.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Bro, does he realize how many witnesses came up on the stand and was like, Trooper Proctor might have wrote that in the report, but that's inaccurate because I'd never said that. He's going to talk to this man about report writing.
Because in time,
I just
the
can't
memory
go away.
is not always as good later on than it is at that moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes,
Or maybe Lieutenant Gallagher, who like doesn't write reports and never did.
Talking shit about his own people who didn't do that.
Literally.
The jury's like, well, where are all these things that we should be able to see from all these better sergeants? Why aren't we
The
seeing
entire
any of
world
them?
is laughing at you. We're all laughing at you, and now we don't know why. Nobody knows why we're here.
you respond to a number of different events and
Just sit down. Just sit down.
incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
Did you at the time?
at the time, correct.
And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
What does it say?
Correct.
That a piece
The
was
vehicle
missing?
had damage to the right rear taillight.
That's what I wrote.
Fair
Okay.
to say you didn't document that it was the size of a dollar bill. You didn't say that, did
It
you?
didn't say the whole
No.
fucking
Or
thing
that
was
it
missing
3
either,
to
eh?
6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote,
Also, like, that's no different than what he's saying today.
And that's why he's saying his memory's doesn't matter because it's the same. His memory is the same as what it was that day.
Exactly.
Not better, not worse, nothing.
Not
Nothing's
even
changed.
that. He was literally able to show you the exact piece that he remembers being missing. And then footage of the ring camera showing the piece he said was missing is the only differently colored piece. The rest is clearly red.
Did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't.
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Yeah, and he said the same thing.
Correct.
A little
And that was
less.
probably a year to a year and a half after you first made the observations, which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
But were you asked about to describe the best you could the damage to that right rear taillight last time you were in court?
So it was
on
cracked
June
and a piece
10th,
was missing.
2024?
It wasn't completely damaged. That's exactly what he
Has to
said.
be the transcript. I'm not going to quote what I said. I don't even fucking remember what I said.
Ask for the transcript because what he said was a piece was missing. It was not completely damaged, which is exactly what he said today.
I don't think I was told to describe it in depth.
Yeah, he
Were
wasn't.
you asked questions about the damage to that rear taillight last time you were in court?
The
I
rear
was.
rear?
And
The
when you
rear
described
taillight?
the damage,
The rear
to
rear.
the best of your ability,
God
to give as much
damn, you
detail as
idiot.
possible.
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed,
Oh my
Time has passed. Yep.
that you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
The rear rear.
And so when you qualified, you were considering human factors like time had passed,
Correct.
that your report was respectfully scant,
Correct.
but you had heard a lot about this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had
What he's
passed
saying now
in
ain't no
that time?
different, sir.
Can you rephrase that?
Yes.
Yeah,
When
your
you
questions-
decided to qualify,
Have we realized that at this point, witnesses on both sides, like his questions literally don't make any fucking sense 90% of the time? Has he ever had anyone found not guilty ever?
The rear rear.
The rear, he even paused. He said the rear pause, rear tail light.
The rear rear.
What an idiot.
He's like, I can't differentiate
He's like,
between the
bro,
rear or the
you are
rear.
the most, I just can't.
and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight. Is the reason why you used that qualification to the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And sir,
Isn't that what every witness has said so far? 3 years later? Yeah, to the best of my ability and recollection, that's what I remember.
since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your
Bro,
testimony
we don't even care. Nobody
on
cares.
June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, okay.
Don't what?
You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in
No.
the conference room.
He doesn't live here. Where is he supposed to meet him? He can't go to his house or his office. He doesn't live here.
Find it odd. Go to somebody's hotel and speak to them about a case.
No.
Without saying the name of the hotel, where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
I'm sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
On TV?
Did you protect your no
I
square?
did.
When you went there,
Do we not find it hilarious that a police officer just told the Commonwealth of Massachusetts that he doesn't feel comfortable telling him where he stays? Not even
Yeah.
the town?
I don't feel comfortable telling you.
Yep.
I'm not comfortable- I don't want you to know where I live, sir.
Exactly. A police officer. Is that not strange?
who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end.
The
The good-looking one down there on the right.
No, it was not.
Did you just call him a good-looking one on the right?
Somebody else.
Yeah, he did.
Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came to the court?
No.
The photograph of the.
Did you say why you were in that hotel room?
The vehicle with the missing glass. Were you shown that?
Conference room. They were in
He
a
said
conference
conference room. He didn't say hotel room.
No.
Were you shown your testimony from last? Okay. Was there anybody else there?
No.
When you were in that conference room,
Conference.
Okay.
were you shown your police report?
No.
Were you shown your testimony from the last time you came to the court?
No.
The photograph of the vehicle in the Sally Port, the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that,
I don't know that he saw it at the last trial.
I don't think he did.
No, they didn't show it to him last trial.
I don't think so either.
So he's confused.
photo during your prior testimony,
No,
you
you weren't.
never, ever suggested that that was in any way different than what you had seen in Dayton.
Nobody asked me that.
When you were asked to describe the damage, and you were shown that photograph, you
He
never,
wasn't shown the
ever
photograph.
Suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Jackson needs to clarify that he was not shown the photo.
I hope so.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
Oh, Hank, trying to pull
When you were asked questions about that taillight, you had described the taillight as
a piece was missing. It wasn't
not completely damaged. It was
Mm-hmm.
cracked, and there was a piece missing, but not
How is that
completely damaged.
Yeah.
Remember that testimony?
I do.
And is that accurate testimony?
Yeah.
It's accurate.
Like, what are you even getting at, sir? It's exactly the same.
So in your memory, in June 10, 2024, was that vehicle's rear taillight had a piece missing, correct?
Correct.
You said that your memory about the damage to the taillight, as you recall it when you were in Dayton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage.
Oh,
right?
here we go.
Right.
So he's going to try to impeach him because he actually wasn't shown the photo. He's going to say you weren't even actually shown a photo, were you?
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
Yeah, see? Oh, shit.
Any approach?
It still doesn't matter to me because his testimony from last year is exactly the same as this year. The only difference is they showed him the picture and he said that's not what it looked like.
Yes.
I'm going to show you your transcript of sworn testimony on June.
Plus, I'm sure he's seen that picture like a trillion places.
Yeah.
10, 2024.
He didn't make up the picture like somebody made up a puffy fucking jacket.
Like right? Like he probably saw the photo like on the news and was like, absolutely not. That is not what I saw.
You've testified that your memory of distinguishing that photo is reflected in your testimony, right?
So ask the question differently.
Okay. Your memory
Hank is
that you discussed the distinction between that photo and what you saw at the last time you testified. Objection.
I'm going to allow that.
And I should take a look at that. Could you show me anywhere in your testimony? Anywhere. Where you made any statement about that photo being inconsistent with what you saw in Dayton on January 29th, 2022.
I don't think this is going to go over as well as he hopes.
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you.
Yes. Correct, Mav.
So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy, they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that
Well, I think he gives it to-
you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah,
And
correct.
you share those
Oh.
same difficulties with memory as many other witnesses. Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting.
No, if we want to meet face to face, cannot be accomplished by phone, sir.
I'm going to allow it.
Over here. What did you talk about?
Excuse me.
So that, okay.
Ooh, back that up. Back that up.
What did you talk about?
Excuse me.
So that, okay.
No, a little bit more.
And then ask me.
Right here.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about?
I'm going to allow it.
Over here. What did you talk about?
Excuse me.
So that, okay.
Ink's all over here. Like, don't look at them, look at me. Over here. Fucking prick. He's trying to like undermine him while he's on the stand, and he's like, don't look at them, like in front of the jury, so the jury can see, like, this guy doesn't know how to answer questions. He's looking at Jackson for his answers. Oh, is Jen's sister there? I don't see her. Oh, wait, behind 20-year-old date. That might be her. I cannot tell. Over on the right-hand side. Yep, right there. Yep. And she's moving her face around. I can see her. Yes, Jen's sister is there. She's hiding her face from the camera, though. Oh, Nunya, yes. From tornadoes? Yes, you missed Barros on the stand saying that he absolutely did not see the tail light looking the way that it did in the Sallyport photo. But now we have Hanky Spanky trying to impeach him with his own questions.
You told us there was some background about being subpoenaed and time.
Wait a minute. Oh, that's her, 100%.
Yeah, that's her, 100%.
So what's she doing here?
She's going to pay attention for Karina.
She's here because Karina is expected to be called, and we know what the rumor is that Karina's going to fucking say. Wow.
I need to add this to my timeline.
Because Jen McCabe would have been too obvious. You know what I mean? But I guess they're hoping that the jury doesn't recognize her, even though literally Jackson made her point Dee Dee out. Remember? She said, can you point her out? What's she wearing?
So, okay.
No, don't tell. Don't say what she's going to say.
I gotta tell Mav.
No, you don't.
I got. Oh, Mav, I'm sorry. I want to tell you so bad.
Because we don't know if it's true.
We don't know if it's true, but it's just a rumor and it's on Twitter.
Fine. Well, why don't we just read the tweet? Let's just read the tweet. Let's just read the tweet. Okay.
Fine, read the tweet. Read the tweet. No, we're going to tell you, Mav. We're going to tell you.
The tweet says, FYI.
It's absolutely true.
Sources are reporting to me that Karina Kolakithis, a witness for the Commonwealth last trial, will testify with a lawyer present that Jennifer McCabe told her that there was ring camera footage of John O'Keefe being hit by a car in an attempt to convince her to turn against Karen Reed. This is completely in line with McCabe's manipulative behavior towards many other witnesses in the days after O'Keefe's death. WBZ also reported this lie on February 1st, the day they were at D&E Pizza, and Matt McCabe texted in a group chat that Chris Albert should tell them the guy never came in the house.
Now, do we know that's what she's going to testify to? No, but we do know that that is the story that has been out for a very long time, and that is what was told to the news station who originally reported that
about there being footage of the incident.
Yeah, that there was footage of her actually hitting John, and that this was shut, like open and shut, and she needed to take a plea deal.
I also think that that's exactly what I was getting ready to say. Is I think that was also part of the conversation, or I guess that was the point, like why they randomly said about if she takes a plea deal, because if she thought that it was on camera and she was drunk and didn't remember, well, then and Jennifer saying that she was saying I hit him, then maybe she'll just think that it's on camera and oh my God, I killed my boyfriend and she's gonna plead out. Is that the date that Jen was Googling herself and John's names? What date did I just say? I believe that the WBV thing or WBZ or whatever, that article saying that there was footage of that, I believe was like on the 29th. It was like that day. Or no.
February 1st, 2022.
What is February 1st, 2022?
I don't know the date you just said.
So February 1st, 2022 is when Brian Albert texts the group chat, Julie said Channel 4 is in D&E. So yeah, that's the day that conversation happened. It's also the day that Jen said Carrie is here going over timeline. And we handed the phone to Carrie. Same day that Courtney texts him and says, just saw Julie. And Julie said, when this is all over, she wants to give you a gift. And then later that evening, Karen Reed is arrested. The 2nd, February 2nd, the day Karen Reed was arraigned, that was when Jennifer was Googling herself. Yeah, he shouldn't have disclosed that, especially if they don't get to her today, which they might not.
You told us there was some background about being subpoenaed and time substantive.
Damn, you're not done yet?
What did you talk about with the attorneys when you met them at their hotel conference?
Other than that, they didn't go over my test.
Now I understand why he's never at the fucking mic. It's because he likes to lean on that banister and put his ass in Mr. Reed's face. Did you see that?
Testimony.
What did you
Look at this dickhead.
With the attorneys when you met them at their hotel conference?
Leaning on the banister. What a dickhead.
Other than that, they didn't go over my testimony. We just spoke about that. I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame? Last year, this year?
Was it winter?
Probably June, early in this year.
Are you having some difficulty with memory about that as well?
Oh,
On
you
a certain
fucking
date, yes.
Not a certain date.
Remembering a certain date is different than, bro,
Was it this year probably? Or do you think you met them this year?
This year.
shut the fuck up.
You know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January? No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV and
Everywhere.
Was it shown to you during your conference room meeting at the hotel?
it was not.
So you looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over
Literally.
social media and the news. You can't avoid it.
Literally.
I'm not criticizing you or discounting you. I'm just asking you. Have you been exposed to this case since you made those observations indicted on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory?
It's not difficult.
I'm going to allow that.
Your Honor, give me approach.
Okay. Yeah. 'Cause, like, he's implying he has a bad memory. He doesn't.
Well, that's the only way. I mean, this is the only way Hank can discredit him is by doing it this way. So
Yeah, he can't though.
yeah, his memories aren't false. That's the whole thing.
You've seen
He's not
Yeah.
just creating false memories. He doesn't
You've seen
remember
quite a
the
bit of
date.
Information about this case.
Literally.
and the issue regarding this. You've seen quite a bit of information about this case and the issue regarding the taillight since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
Wow. Even more interesting. Someone tagged me in a thing on Twitter, an article that says Sergeant Nick Barrows, a 7-year veteran. This was March 15th, 2024. So before his testimony in the last trial. Sergeant Nick Barrows is a 7-year veteran of the Dayton Police Department. He hasn't been in a cruiser since October 9th, 2023. Barrows told 12 News he was driving his cruiser down Route 44 that night. He was hit head on by a drunk driver.
Mm-hmm.
I'm lucky to be alive, Barrows said. When you see a car coming straight at you like that, all you can think of is death. Barrows said he had his lights and sirens on since he was responding to a call. He remembers looking at the speed radar in his cruiser and seeing just how fast the oncoming car was barreling towards him. The number shows up big and in red. It said 70 miles per hour, he recalled. The car kept getting closer and it began drifting into my lane. I just held onto the steering wheel and I knew this car was going to hit me. He tried to swerve out of the way at the last second, but it was too late. I just heard a loud boom and I saw white, he said. I thought I was dead. Though his cruiser was mangled, Barrows was thankfully still alive. My first instinct was to run over to that other car and check on that driver, he said. The driver, identified as 30-year-old Michelle Souza, has since pleaded guilty to operating under the influence. He said her BAC was well over the legal limit. She could have killed me. She could have killed someone else. Barrows was seriously wounded in the crash. He wound up with broken bones in both of his hands and burns the size of softballs on his side from the airbags deploying. He's still coping with numbness and tingling in his hand, which is why he hasn't returned to work. And the pictures are just like devastating. I mean, the car was just destroyed.
And we showed him last year. We showed
Oh,
that
did
article. Uh-huh. So
I
are
guess.
you saying that you have memory issues?
Probably.
100% yes.
Yeah.
We do.
Or probably, I mean, like, absolutely.
You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
I'm like a fucking
Would
kid.
you agree that you have some difficulty with the memory?
I'd agree.
I'd agree. But, like, you're still a piece of shit, and I still remember what I saw.
I want to show you some evidence of that taillight before you had a chance to see it in Dayton. If we could have the ring video at 5:07:58, please.
What?
He's going to show him the video. He's going to show him the. Oh, wait, did he say ring video?
He did. He said ring video. I think he's talking about the dash cam video, but.
Well, I thought he was talking about the dash cam video. So if he's going to show the ring video, that don't show anything different than what you saw on the.
Unless he's going to show her backing up.
Let's see what video he's talking about first. Hurry up, pan faster. Oh, so it is ring video. So he's going to show the taillight and say, does that look like what you saw when you saw it? Like we should be going off of this rather than the full clear photograph of what it looked like of the whole taillight. This is just ridiculous. I'm sorry. We need to be finished with him.
Have you seen this video before, sir?
I have.
Before you proceed, let's go.
God.
Have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
None of that makes a difference.
Too many to count.
Last year he said there was a
Because you were
piece
involved in this
missing.
case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look compared to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. Who's like this? Stop, please. Do you see that white part of the back on the right taillight? Objection.
I'm going to allow it.
No, I don't fucking see anything.
See that?
Just
Sir?
see the bottom, how it's all red
Zoom
right
in
there?
A little bit more.
See all that red? See all
I
that
can.
red?
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. Stop it. Can you bring it back, Ms. Stone? Back more. Open, right there. Zoom, please. You see, sir?
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day?
Yes,
And when you got to the driveway, it had not been shoveled or plowed.
correct.
There was quite a bit of snow accumulating and ongoing.
Yes,
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes,
When you looked at this house, when you looked at the defendant's Lexus indictment, you didn't go over and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Okay, we have Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part
I can.
missing? Yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dayton? Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear taillight and the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay, lights on, please, Mr. Jackson.
Thank you, Your Honor. I'll be brief. Sergeant, did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain this to the form, Mr. Jackson, is
Of
your
course.
witness.
Of course.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Good.
Correct.
Do you remember where you went? Do you remember what you got? Do you remember everyone that was there? Do you remember what you wore?
Yeah. Was it sweatpants, sir?
You remember being in Dayton,
What an
correct?
idiot Hank is.
Being called out to Dayton to the residents of the Reeds.
Correct.
He looks so amused.
Do you remember the time?
He hates Brennan.
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you
Wow.
remember being in the garage and speaking with someone?
I do.
Remember it was this lady, pretty lady right here in the blue?
I do.
You remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that? Right?
Mhm.
Hank
Do
looks
you
like a
remember the
fucking idiot.
SUV?
I do.
Do you remember the condition of the taillight?
I do.
I'm dead. Look
And
at
again,
Hank
sir,
staring
You
at
were
me.
asked
Hank,
whether or not you
put your head
saw
down and shut the fuck up.
Trooper Proctor in any way manipulate that right rear taillight while it was out at Dayton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sally Port in Canton PD?
Oh.
I'm sorry, in Canton, in the Sally
Exactly.
Port at the police station
I wasn't.
at 5:30 p.m.?
Objection.
Sustain.
At any point, did you ever go to the Sally Port at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sally Port?
Objection.
Sustain.
Nope. Why, Hank?
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
Maybe someone should
Was
have.
that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Yep.
The form, Mr. Jackson.
Of course. What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
Somebody needs to ask, how many times do you testify?
And you were called by whom?
Yeah.
You need to ask him that. Like when you testify in court, who do you normally testify for? How often have you testified for a defense team?
Last year at the other hearing. The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Oh, maybe he will.
Correct.
Better
So that's stricken.
Why?
the way he asked it.
So just say when you testified last year, who called you to testify?
Yeah.
And did they call you this year, sir? Nope.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
Wow.
And you testified last year that the taillight was cracked, but not, or damaged, but not completely broken, correct?
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles,
Correct.
I have to
I have a
stay at a
house.
hotel?
right?
Correct.
I don't have an office out here, correct?
Yes.
Sustained.
Do you
Exactly
know
what I
whether or not I
said.
have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barrows, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022 at about 3 or 3:15 in the afternoon when you saw the vehicle? Any
No.
difficulty whatsoever?
No.
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
You would agree that your memory has changed since last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dayton on January 29, 2022?
Objection.
I'm going to allow it. It was opened
That's
up.
not evidence.
It was opened up.
What was
Is it
it?
consistent
What was
with what you
opened?
saw
First of all, what was opened? Because you can't open your own door. So what was said?
on January 29, close-up with the missing right rear taillight has changed since last.
No.
You would agree that your memory has changed since last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is
Who said it's missing?
that consistent with your memory
Oh, the Sally port.
of what you saw in Dayton on January 29, 2022?
Objection.
I'm going to allow it. It was opened
That's
up.
not evidence.
It was.
He didn't show him a photo of a missing right taillight. That was on direct.
Opened up.
What is opened? Like what? What is happening?
Consistent with what you saw on January 29, 2022.
It is.
Thank you.
All right, Sergeant, you are all set.
What? Is he talking about the ring footage?
I don't know. I can't tell because they're just showing stuff and not telling us what they're showing.
That's it. Thank you. Whatever. Still fucked. Hank is fucked.
All right, so jurors, I know I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bring you.
Oh, we didn't get Lucky or Karina.
So those same cautions. Please
Tomorrow.
Oh.
Okay, piling up.
Jury's exit the court, please be seated.
So there have been some motions, I think, piling up. Two, I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Ms. Gianetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time. I just don't know what you're talking about. Sure.
God damn.
Hmm.
How come we read all the motions and you haven't? Like, you literally get paid to.
We don't.
Yeah.
All these streams are being demonetized. There's not even going to be ad revenue on most of them.
Yeah, and we literally make the time to read them. Like,
Yeah, we don't get 5 cents, fuckers.
I haven't even read them.
I'd like to read them before I hear you. Why?
Like, what about all the breaks you get? Like, when you're
What the
sitting
fuck
there
have you
eating
done,
lunch.
Bev? Stop drinking and start reading.
Well, when you're drinking, you can read.
She's like, I have a bad memory, and I can't remember what I read yesterday at 5 o'clock.
Are they not even going to say anything? Everyone's
No.
leaving.
Yeah, they're done. They don't want the public to know. When was the sidebar that you were reading from Jessica that said something about Bev being loud? I wonder what sidebar that was now that I should have paid attention when it was coming up and I didn't. You called court short today. Yeah, I mean, you always get that. They get the recross. They get redirect and they get recross. Sometimes they even get a redirect. But they both get one. They did it last trial too. Both sides got the redirect and the recross. But she's been allowing both sides to do a redirect. I'm actually surprised that Jackson didn't throw something out there with Barrows, but I think he made his point. And as much as I don't like Hank, Hank did what he could to try to recover from that extremely damaging testimony of Barrows. I mean, there's nothing else he could have done to try to save the Commonwealth at that point.
Yeah, well,
he's just a little rat. So, I mean,
you could have not looked like a piece of shit by doing what you did. Like, you could have just been like, you know what? Okay. Like,
he is a piece of shit, though. You can't expect him to not be a piece of shit.
I'm confused by the last question and answer too, because it can't have been one of the ones that he showed him on his cross because Jackson said it was not in evidence. So I'm confused.
I rule for the CW. You are all set. Have a good day. We have a new filing, Sleuthie.
Oh, is there?
We have a new filing and Sleuthie. We have a new Sleuthie? I'll drop it in Messenger if y'all are interested. Y'all are interested. Let's do it. I got a little bit of time still before I got to go. New filing by the CW to exclude expert testimony.
Oh, God. All right, I'll read it. Thank you, Joanna. So this is the Commonwealth's. It says on June 1st, 2025. When was that?
It was 2 days ago.
Sunday? Sunday?
It was on Sunday, yes.
Okay. Okay. The defense produced to the Commonwealth a new report from defense expert Derek Ellington. Do I have that person on my witness list? I don't remember that.
No,
name.
I can't even keep track. We've got so many other people that I don't know.
Yes, Derek Ellington is number 85, ACFE certified fraud examiner / digital forensics. Okay. The new report appeared with no prior notice from the okay, well, that person's on the list, Hank. So appeared with no prior notice from the defense that it was forthcoming, and it was dropped on the Commonwealth 3 months after Mr. Ellington's prior report in this case, in the midst of this trial, and after the Commonwealth had rested its case in chief. Well, Hank, that sucks, doesn't it? Mr. Ellington now offers new opinions on entirely different issues that were not set forth in his prior report. Could it be because they were brought up in your case in chief, maybe? To prevent further ambush of the Commonwealth by the defense in this case, he should not be permitted to testify to his new opinions. If he is allowed to do so, the Commonwealth hereby provides notice that it will present rebuttal testimony on those issues. That's fine, sir. Background. The defense previously disclosed to the Commonwealth a 13-page report from Mr. Ellington dated March 3rd, 2025. A copy of that prior report is attached as Exhibit A. Essentially, the report quotes from or describes portions of the reports of Mr. Whiffen, Ms. Hyde, and Trooper Nicholas Guarino concerning certain data retrieved from Mr. O'Keefe's iPhone for the time period of January 28th to 29th, and then states whether Mr. Ellington agrees or disagrees with the analysis and findings of those experts. Mr. Ellington's specific conclusions and opinions appear on pages 9 through 12 of his report. His report.
Everywhere.
Did you go in the grass?
No.
Oh, no, it's in the floor from my boots. Sorry.
You said we have to keep the house clean.
We do have to keep the house clean. Mr. Ellington's specific, we have to go to Walmart, bub. Conclusions and opinions appear on pages 9 through 12 of his report. His report did not address, much less offer, any opinions or analysis regarding either the data on the defendant's iPhone or any data on Mr. O'Keefe's iPhone after the time that device came into the possession of law enforcement. Why would he care what showed up after it was in the possession of law enforcement? Ew, I was looking for this earlier. Thanks. On June 1st, 2025, the defense produced to the Commonwealth a new 16-page report from Mr. Ellington dated that same day. A copy of this new report is attached as Exhibit B. In this new report, Mr. Ellington states that he, quote, was asked to focus specifically on activity and interactions logged on the two devices, i.e. the iPhones belonging to Mr. O'Keefe and the defendant, after the times of seizure / surrender of the devices to the ultimate custody of the Massachusetts State Police, including a review of GPS data points captured on the Reed phone. Nowhere in the report does he explain why he was asked to perform this new analysis or when he received such direction from the defense. Nor does he offer any explanation for why this new analysis was not included in his prior report. I mean, at least he was honest about being asked to do it. Indeed, Mr. Ellington identifies the materials that he relied on for his new report, all of which were available to him at the time of his prior report. Accompanying his new report were several new spreadsheets of information that he created and that were not previously disclosed to the Commonwealth. On June 2nd, 2025, so yesterday, the defense provided a one-page amendment to the June 1st, 2025, clarifying a notification on John O'Keefe's cell phone. A copy of the amendment is attached as Exhibit C. Mr. Ellington now purports to discuss and opine on industry standard best practices for handling seized devices, investigate the timeline and circumstances surrounding the seizure, and forensic imaging of the 2 iPhones by law enforcement, and conclude that, quote, there is no evidence to support that the devices were handled properly by law enforcement, and thus allegedly there is and will always be a high level of uncertainty regarding the validity and accuracy of the O'Keefe and Reed mobile device data. And then here's the argument. Mr. Ellington's June 1st, 2025 report presents opinions and analyses that are entirely new and beyond the scope of his prior March 3rd, 2025 report. His new opinions and analysis could and should have been addressed in his prior report if the defense intended to raise these issues. It is far too late to do so now, after the Commonwealth has completed its case in chief and its digital forensics experts have already testified. Moreover, the defense has indicated that they intend to call Mr. Ellington tomorrow. Well, that obviously didn't. Oh, this was filed June 3rd. The Commonwealth has not had and will not have sufficient time to prepare for these new opinions before he testifies, even if the defense should be permitted to present these opinions in violation of their discovery obligations. In the interest of basic fairness, the defendant should be precluded from eliciting any testimony regarding the topics, opinions, and analysis in Mr. Ellington's new report.
Okay. That's nothing that she just talked about this afternoon, right? That's not one of the motions she just talked about.
No, this was just filed today.
Oh. Okay. Oh, I can't keep up with him. Oh, no, they aren't, Hank. You're just stupid. Where's Marco? He could have written a manifesto. He could have written a poem. I mean, he could have. He could have written a poem.
What did you just pull out of there?
Oh, Jesus.
What
All right.
bag?
So tomorrow.
10 a.m. on the dot.
Tomorrow, yeah. And we should have Lucky Loughran and Karina Kolakifas.
Mm-hmm.
So that should be interesting. They would have been there today, but Hank had to take forever with Dr. Russell, so she couldn't come back to Cali.
He wanted her to miss her flight on purpose.
Probably.
He's a spiteful little bitch like that.
I'm curious. I'm curious what the jury thinks of Dr. Russell. I don't think he was able to overcome her being a good witness for the defense. I just don't think so.
Bro, if I was on the jury and this officer just sat there and said what he said, I don't give a damn what Hank said. I really wouldn't, because
if I was suspicious before, they get the tow truck driver on too, who substantiates what Barrows just said. It's not going to matter what the fuck he wore on his birthday 2 years ago.
But like, what are the odds? Remember we talked about this and I was like, what does he expect them to say? Like, is the expectation that they're going to be like, yes, we did. I'm going to tell my friends. Oh, that was what it was. I'm going to tell my friends in a group chat that we did frame Karen Reed and that we planted evidence. And I was like, we expect them to actually have done that? Like, that doesn't make any sense. The next best thing, you have an officer going against other officers and saying, I was there with them. I don't know what happened after they took that car out of that driveway, but when I was in that driveway, this was what the car looked like. And that's good enough for me.
Mm-hmm.
It also discredits Jen McCabe and Carrie Roberts, like I said, because they looked at the same photo he just looked at of that car in the Sally Port and said that was consistent with what they saw, and he did not. So I'm going to put clothes on and go to Walmart and maybe go to bed early so the morning can come faster.
All right, we'll see how that works out for you. I'll set the stream up when I get back from picking up the tiny human.
This was better than, like, after yesterday, dude, I thought we were plumb burnt out. Today I feel renewed. It was way less boring. And I look forward to what all's coming up because now I don't know what they're going to do.
Right.
You know what I mean? And if Karina says that, oh my God. Dude, if Dee Dee's there tomorrow, I haven't seen Dee Dee at all because when I've pointed out the ex-girlfriend that John went on a date with to the movies 2 decades ago, being in there every day, I would have seen Dee Dee too.
Well, she was there with Jen McCabe. No? Or was that trial 1 when we...
Dee Dee
No.
was only there when Jen McCabe testified this
Yeah,
time,
that was
and
this
Alan
time.
Jackson. Well, I don't know if she was there last year, but this year, the only time she was there was when Jen McCabe testified. Jackson had her point her out.
Yep.
And she hasn't been back since. Now, all of a sudden, she shows up when Karina Kolakithis is supposed to say what she might say. Not great.
All right, go do your stuff. Never born with the tea and the goose. It's the goose tea. The tea goose. I don't know.
The UV
whatever.
index is supposed to be high again tomorrow. So I'm gonna try to better manage my time. I'm gonna like look ahead, see when I have some time to go sit outside.
I just gotta tell you a funny story before we go. So the UV is like a huge thing, obviously. Like all the teen girls are like checking the UV to see if it's like, if it's a good day to go lay out. That's like
Is
the
it
thing.
wasting my time to go outside or no?
So today was because this is the last week of school, and Kaylee's graduating or promoting from 8th grade, and so today is supposed to be 8th grade ditch day.
Mhm.
And I'm a terrible mom and didn't let her ditch, and I made her go to school.
My mom never let me do it either.
So so yesterday when her science math teacher was talking to them about whether they were going to be here, because like everybody in the school knew it was going to be ditch day. And so the science math teacher was talking to them, and he was like, so like, if you guys aren't going to be here, like, what are you girls going to do tomorrow? Because the UV is not even going to be any good. An old fucking guy. I was dying. It's like, he's like checking the UV, and Kaylee's all, and he was right. It's not a good day for UV.
He knows what's up. Yeah, I like earlier it was at 10. I was out there from 10 to 9 when it went from 10 to 9.
Uh-huh.
I have some tan lines. So I'll go out in little spurts. Like even when we go down the shore, like when we go to my mom's beach house, I'll go to the beach for like 3 hours. Like I used to lay in the sun all day. Now I just get bored unless I'm listening to something.
Oh God, I could just lay out at the pool. I'd have a pack of cigarettes and a 6-pack of Bud Light. That's where I spend my day. Man, I miss.
Well, I
those
don't
things.
drink, so I get a little parched.
Well, I don't drink anymore either, but that was back in the day.
And my kid will be like, "Can we go in the water?" And I'm like, "Well, I don't want to go in the water because then my lower body won't tan." I'll watch you from here. If I could get a float and I wasn't scared to like float away. Oh, maybe I could put like an anchor on the float. Maybe I can go get some like
anchor the float.
Yeah, I can go get some
Just tie it to the rail of the pool.
No, we go to the beach.
Oh, you want to float in the beach?
Yeah, so maybe I'll get like some sinkers that we use, like the big ones for ocean fishing. Maybe I'll tie some sinkers on it.
Oh, that's good UV at the beach.
Oh, inside the ocean? Oh my God. Like it literally doesn't get any better than that.
That's right.
I think it's something about the salt water that like, I don't know if it like opens your pores or whatever. Dude, when I lived in Florida, I had like the clearest, most beautiful skin that was tan all the time. Like the beach, I'm sorry, but the beach, if you could live on the beach, if I was homeless on the beach, I bet I'd still look good. I would just
if I
be
was homeless, I would live on the beach.
Oh, absolutely. I'd head straight for the beach.
Yeah. But that's a problem because that's where a lot of homeless people go. Found a dead homeless guy there once.
Oh, that's sad.
All right, I got to go.
Okay, me too.
All right. We'll see you guys tomorrow. Thank you guys for hanging out with us. As always, we love having you guys here. We know you have 1,000 other places.
What are you cutting? Are you cutting something? What are you cutting?
I'm not cutting. I don't have anything. I promise.
I hear scissors, so we better.
I don't have scissors.
No,
I don't even have scissors by me.
He has scissors. I hear him in the living room scissoring something.
I will see you guys tomorrow for day number 27 in the state of Massachusetts versus Karen Reed in her retrial. Go enjoy the rest of your Tuesday. We love you. Thank you for being here. Bye, Sleuthie.
Bye. Love you. Love
Do you dare to follow me down?
Okay, that's weird. Why is it not playing my stuff?
Into the